2 weeks after. Yeah, reason
Item
is
43 adjourned.
interim order is there. Interim order to continue.
I mean, if I don't mention your lordship, Belgium matter.
Give the memo.
Item 43, interim order to continue.
Is there the other side is there?
Other side there.
Who is the other side?
Not present.
Mark it and keep. When the matter will call, we'll see. Okay, next, item 1.
Item 1.
Here.
For example, the reviewer bail order has not sufficient.
What is it?
Exam the bail.
Huh? Sorry?
Exam the bail, Milord.
When you were granted bail,
Granted bail, I have given the copy by virtue of an order passed by this honorable court.
tell me the dates.
28/10/2011.
28/10/11.
2011.
Then NVW issued
And
by.
NBW was issued on 28/2022.
Why you were waiting?
Milord,
Waiting for such a long time, 3 years, 2 years about.
22, Milord. This petition
August.
is pending long since.
Eh?
This petition is also pending since last March.
20th August 2022. Huh? 20th August 2022. Now I think I'll have to start a trend of imposing some cost for the benefit of the bar. How much you will pay?
But you'll also be starting from me.
Yes.
Yes, Milord. Your
Starting
Lordship
from
actually.
item 1
Item 1.
for the benefit of the bar. How much will you pay?
Lordship.
No, you tell because it is starting, so therefore I will
So
start it.
some leniency should be given as I am the first one.
How much you tell yourself?
Per month, you'll also make fixed 50 rupees.
50 rupees.
Per month. 1 year.
Okay, how
No,
much?
what
No,
the-
then what? What is it? Right down. The Land Council for the petitioner has filed this petition seeking quashing of order dated 20th August 2022, whereby the Land Trial Court has issued NBW against his client. He submits that his client was admitted to bail on 20th October 2011. And he has been appearing in the court since then. However, for the default on the particular day, the NBW has been issued. Having taken into consideration the facts and circumstances of the case, the order dated 20th August 2022 is set aside, and the petitioner is directed to submit to the jurisdiction of the court below and subject to payment of cost of rupees 1,000, 1,500, 500, 1,000 to be deposited with the welfare fund of Bar Association. You have a welfare fund?
Welfare fund. High Court Bar Association welfare
High
fund.
Court Bar Association welfare fund.
You'll also make some 500 each.
500 each, subject to deposit of cost of 500 rupees each, to be deposited with the welfare fund of the
Odisha High Court Bar Association.
High Court Bar Association. High Court Bar Association. High Court Bar Association. The petitioner shall appear before the court below as and when directed by the trial court.
One prayer. In the meantime, after issuance of NBW, it has been, split off. 17 now, 17A. From 17A. My case number is 17. After split off, it is.
Memo.
You just give the particulars for the right. Okay, next.
Great.
Able to 2.
My Lord, kind permission. I am in BC, my Lord. I may be kindly allowed to,
Yes.
my Lord. Here, my Lord will see the petitioners, my Lord, are facing this criminal proceeding, the my Lord, criminal case which has been filed by the private opposite party number 2, where, my Lord, all the 4 petitioners, one petitioner 1 is, my Lord, working as the, my Lord, manager enforcement TPNODL, and another, my Lord, lady Minerva Roy, he also working as manager, and all 4 petitioners, while discharging the official duty, my Lord, the complaint has been
You are
filed
against
under
the cognizance order.
cognizance as well as one complaint, both, my Lord, Annexure 1 as well as, my Lord, the cognizance order. My Lord, Annexure 6, page 41. Both,
No,
my
no.
lord,
Your prayer is for annexure,
quash the annexure 1 as well as annexure 6, my lord. My
annexure
lord,
1
the
is the complaint.
complaint, my lord. Vexatious complaint, which is filed admittedly, my lord. Kindly see, the case is filed after the, my lord, the petitioners have conducted search in the premises of the petitioner and taken action as per the Indian Electricity Act, and proceeding was initiated where my lord knows that 126 of my lord, the
Who are you? Who are you?
I am the officers of the my lord TPNODL who are discharging the public duty. All 4 petitioners,
TPNODL.
my lord.
What is the
My
allegation against you?
allegation that kindly similar. The page 31 starts, page 31.
He come to 32, page 32.
Yes, relevant.
Yes.
That the complaint is livelihood established a water service station in near Choda Chowk, Jajpur Road, namely styled as Bharat service station, and for operation of the same, he took electric connection of 6 kilowatt load for his service station premises, being consumer
You
so
have
and so.
demanded bribe.
I raised a milord demand. This was in the month of June. He filed a complaint in the month of August. While the petitioners are discharging their public duty, this case has been filed. As milord settled by your lordship.
Demanding bribe is public duty.
No. That is a complaint,
That is
milord.
the
That is
allegation.
allegation. But kindly see, the later on, the assessment was levied 2 lakhs 12,033. Milord, my submission, the case is instituted by the informant, the complainant, that while his premises was searched, the petitioners misbehaved and demanded bribe. This is the allegation. And milord, accordingly, the cognizance was taken. But when milord, the protection is as guaranteed under section 197 CRPC, even excess duty as if milord, so-called whatever may be.
Demand of bribe and the language you have used as per allegation.
My lord.
Just in between page 32.
My lord.
For that, where is the question of sanction?
No, my lord. That is the, my lord, even so, for the sake of argument, not considering, they have, my lord, demanded money, bribe, and the, my lord, excess, whatever the in discharge of duty excess. My lord, it is, even if, my lord, I will also demonstrate there is the allegations which have been filed, the trial has not been started. But the protection as guaranteed under section 197 CRPC, as my lord settled by Honorable Supreme Court, my lord, I will see, even if some excess duty is there, that may be
the
protected.
duty is something different. 2 lakhs something is different. That is the provisional assessment order is that something different. Demand of dowry is something different. Use of language, just see, I can't read those language here in the open court. See the language you have used.
This is the why, my lord, these allegations have been filed only to, my lord, harass these government servants. Even, my lord, I have settled position of law.
May be also true. Who knows?
My lord, that is why, my lord, I'll demonstrate, my lord. The investigation is in progress because cognizance has been taken. Trial has to be started. So far, even if
of investigation, it is a complaint case.
Complaint. So far, my lord, my submission is that as per, my lord, Honorable Supreme Court has held, even I will take you 2-3 paragraphs. Even if excess, my lord, in course of, because admittedly the petitioners have ventured to the investigation of, my lord, the theft of electricity and meter tampering.
I am not on that, the excess part. The demand, the assessment part, that will not attract the offense. Offense is being attracted by 2 things. One is you have demanded the bribe, and in since they have refused to give bribe, you use this language. Just read in between page 32. If this is the statement in the complaint, and the 200 statement is there. And cognizance is taken. Where is the question of
with great humility, I will satisfy, my lord, that even if this complaint, my lord, my submission, that the complaint is a vexatious complaint. Even the allegation is made out, but that has to be, my lord, proved. And so far, the 197, my lord, it is a settled law.
I am saying it doesn't come under the color of duty. Just read the allegation.
My lord, normally these type of complaint are being only filed to
Right,
harass
but
the
that will
government
be tasted-
servants.
That will be tasted, not 482.
My lord,
Will
yes,
you
my lord, I will,
reserve your
I will,
right to argue all these points at the time of?
then I will satisfy. Your lordship may keep it to next week. I will come with citations because, my lord, the vexatious complaint has been filed nowadays only to, my lord, attract
Mr. Mishra,
offences.
there is no point keeping it. I'll just dispose it up.
My lord, kindly see, kindly next
If,
week. I have to some, but kindly next week. I will come with the citations. I will come in physically, my lord. There are some,
Citation on 197 you will show, I know that.
my lord. I will personally,
197 doesn't come in this case.
I will personally appear, my lord, kindly next week because I have some difficulties in the PC, appearing PC. Next week I will come. Your lordship
And
pass forever.
if you try your luck, the court
No,
will ask
no,
you
no.
if you want an adjournment, then I can't.
No,
adjourn.
no. Next week.
But I would have the same opinion next time also.
But I will try to, my lord, convince with some judgments. I will try to, my lord, convince. In physically, I will appear.
Second week of
My
February.
lord. Obliged, my lord.
Yes.
Item 3.
May plus week.
Three cases.
Three cases,
Yes.
three proceedings of the affair were lodged in the year 1999. And my prayer is that so that the quashing of the criminal proceeding on the ground of inordinate delay in disposal of the cases and the latches my lord on the side of the prosecution. My lord,
Latches in the side of prosecution will be tested in 482 at this stage.
because my lord, so that the inordinate delay in disposal. of the
Latches you
cases-
will derive benefit ultimately.
Section, so far the Article 21, right to speedy trial, my lord.
You are asking for a speedy trial only in all the three cases?
No, all three cases, I prayed for quashing of the criminal proceeding, my lord, because of the delay in.
Why
disposal of
three
the
cases then?
20
There are three
in the
cases
meantime.
against you.
Yes, my lord, 24 years, my lord.
1 minute, 1 minute. This is Nursyang Charan. You have three cases against
Three
you.
cases, my lord, the allegation, my lord.
Three different cases.
On the same, my lord, the installation of tube wells. My lord, they made allegation that the tube wells were not installed. And accordingly, prosecution has been lodged against the officers of the agricultural department. Three proceedings, my lord, I have annexed the FIR at page 14, my lord, kind of plans. What is the allegation?
Yes. These
During-
FIRs are 99.
Yes, my lord, that is my, the FIR of the 99.
But the delay
In
part
first
is,
case, 99.
All
Second
cases,
case,
all cases.
what is this? 99, you have not concluded the trial.
no, thing is that
What is the stage of trial?
so far delay is concerned, delay is also attributed to the accused petitioner. And your lordship,
How would you say that?
your lordship kindly see, we submitted final report.
Huh?
Thereafter, honorable court was not accepted the final report and sent it for obtaining sanction. And after obtaining sanction, again charge sheet was submitted along with the sanction order. Then cognizance was taken in 2008. Thereafter, petition is not appearing somewhere rather, so far as instruction is concerned, petition is not appearing for framing of charge. He is filing petition order 317. And in 2022, it was directed, the case was transferred to the
You give me the dates. FIR dated.
FIR dated
FIR date. Give me
29/9/2019.
29
9/2019.
in all the three cases.
all the three.
Yes. Next, charge
My
sheet,
lord, this charge sheet, no, it is the IO submitted, my lord, the final
closure
from-
report.
that no case was made out.
Yes.
That is on 27/12/2000.
Huh.
9.
27, 12,
2000.
2000. Okay.
My lord, then my lord, kind of a glance, I have annexed the order sheets. Page
Tell me the
90.
facts.
Yes, my lord.
Next. Dates.
Then my lord, on 9/4/2000, the 9/4/2003,
Hmm.
the Law and Trial Court directed the investigating officer to obtain sanction from the competent authority.
No, after filing closure report.
Yes, my lord.
After filing closure report, where is the question of sanction?
That irregularity is there. but
No, no, no.
that can be
That I will
challenged.
satisfy.
Huh.
Let him complete.
Then on 9/4.
At least tell me the right facts. If
That
the
right,
closure report is filed,
yes, ma'am, that is reflected in the order.
then why
sheet.
sanction then?
May I clarify,
Yes,
my lord?
let facts. you are-
Since closure report was insufficient of evidence,
Huh?
Learned Court below did not accept the final report.
Right.
And he directed that there is materials. So you have to obtain sanction for the purpose of, because he is public servant, he is file charge and so that he can proceed and take cognizance. Without sanction against public servant, no
Right.
concern.
Okay.
So accordingly, sanction was obtained, sanction order was obtained
On 9/4/2000.
नहीं
No.
sanction order obtained and 23/12/2008 रे sanction order was received by the SP and it was submitted before the court below for commission of offence under section 13.
What have you done for this 8 year? Closure report and sanction?
In 2003 they sent it for obtaining sanction. Thereafter further investigation and with the fresh material that was submitted before the sanctioning
When
authority.
have you filed charge sheet?
No further.
ଚାର୍ଜସିଟ୍ ଏଟା 23/12/2008 ରେ ସେ ସାଂସନ ଅର୍ଡର ସହିତ ସବମିଟ ହେଲା ଦେୟାର ଆଫ୍ଟର
ହଁ।
କଗ୍ନିଜେନ୍ସ ୱାଜ ଟେକେନ୍ ନା ତାପରେ ସେ ଆକ୍ୟୁଜ ଆଉ ଆପିୟର କଲେ ନାହିଁ
Cognizance बताओ.
ନାଇଁ 2000 ରେ ହଁ କଗ୍ନିଜେନ୍ସ ହେଲା 23/12/2008
Same day.
ସେମ୍ ଡେ
Okay.
ଦେୟାର ଆଫ୍ଟର ସିନ୍ସ ଦେନ୍ ଆକ୍ୟୁଜ ଦେନ୍ ୟୁର ଲର୍ଡସିପ କାଇଣ୍ଡଲି ଟର୍ନ ଟୁ ନେକ୍ସଟ ପେଜ 17/7/2012 ଆକ୍ୟୁଜ ପର୍ସନ୍ସ ଆର୍ ଆବସେଣ୍ଟ 15/2/2014 that is miscase was filed under section peruse the case record further proceeding this case stayed by honorable court this court has stayed till next date accordingly further proceeding was stayed by honorable court till next date because of the order passed by this court perhaps he was earlier before this honorable court the stay order was there because of that stay order then CRLMC number 333 of 2014 there was a stay order. Because of I think because of that stay order, the
No.
trial could not proceeded. जो चार्ज से देइछन जो order
But
sheet में.
whatever, but the fact remains this is somehow attributable to him also, but it needs to be expedited.
Yeah, that we don't dispute.
CRLMC
In the
application-
meantime,
And all the three.
My
cases.
one submission.
Yes.
So by the CLMC application is concerned, my lord, that was filed in the year 2014 and after my lord.
What is the stage of trial now?
4 to 5 months. My lord,
trial
that I am
charge में
convinced-
ही चल रही
No, I am
किसी केस रे
convinced-
तीनटा केस
the
अछि
charge was framed
गोटे
on 26/8/2016.
हाँ
26.
My lord, then my lord, can I have a glance? I have unlike the order sheets. My lord, can I have a glance? Page 28 for a moment, 28 onwards.
नहीं तो पूर्व देखो 21 नु 2019 से accused absent तापरे
Charge for it, my lord, can I have a glance? Page 28. Hence the aforesaid last line, my lord. Hence the aforesaid charge sheet witnesses is not examined, put up on ethics for submission of list of witnesses by the prosecution. Then, my lord, it continued 15/3/2017. Then it is continued till.
But
when
you
your
see,
lordship-
you have been absent in all the occasions.
No,
And
unless-
15/3/2000 again the accused is absent.
No,
And
unless,
every time you are absent.
unless they submitted the list of the prosecution witnesses, the role of the accused person not there, my lord.
317 again you move.
Because they have not submitted my lord, the list of the witnesses.
Accused persons are absent.
My lord,
Accused persons are absent
After
everywhere.
the supplying of the PP, my lord, charge was framed. The next, my lord, they have to supply the list of the witnesses. Unless they supplied the list of the witnesses, the accused persons have no role.
Right.
Then my lord, what I am
right.
submitting, my lord. I have some. My lord,
I understood it.
my lord,
I am not going to
I
quash
have some judgments, my lord.
No judgment. I am not going to quash it. I'll tell you. I'll expedite it, having note the fact that even you have delayed the proceeding.
I
Still,
have not delayed.
I could see that attributable to you, largely attributable to you. But I'm not on that. But the fact that the case is of 1999, FIR is 1999, na?
my lord
1999. It needs to be expedited, and I'll fix how much time.
6 months.
I'll make 3 months. 3 months, you finish it up.
My lord the accused to cooperate.
Accused has to cooperate.
My lord.
I'll bound him
And
down.
so far the-
My lord.
my lord,
I'll bound him down.
My lord
my lord, so far the departmental proceeding you are concerned, I have also ignored by
You will be acquitted, sir. Why do you worry? Nothing is there in this. You will be acquitted within 3 months. Why unnecessary?
and
Better that you should be honorably acquitted. All the 3 matters here. The petitioner has invoked the jurisdiction of this court under section 482 CRPC, seeking quashing of the cognizance order
no, looking at the entire criminal proceeding of CR case number.
in all the 3 cases, na?
my
Yes,
lord
Proceeding, the criminal prosecution initiated against him by the opposite party.
Vigilance
In all the 3 cases, numbers are different. In TR case 28, first case mein, in TR case 28 of 2008, pending before the special judge vigilance Cuttack. Cuttack. This is the first case. The same thing numbers will change. Okay. Next paragraph. It is submitted that the FIR came to be registered on 29/9/1999. Although closure report was filed by the prosecution on 27/12/2000, further investigation was directed. After obtaining sanction on 9/4/2003, the charge sheet was filed. Again, the charge sheet was filed on 23/12/2008.
Again, charge sheet was not filed. So
Yes,
re-investigation was not conducted. Khali sanction they have obtained. That was my.
Along with the sanction, they filed.
They have
That's
to.
the charge sheet. On what?
After obtaining sanction for 9/4/2003, again charge sheet was filed on 20.
Filed accompanying the sanction granted by the competent authority. Full stop. The Learned Trial Court took when the charge was framed, 26/8.
First case 26/8/2016.
In the first case, बाकी सब देखियो. Second case वगैरह देखिए just कोई दे मत है फटाफट date उड़ा. Right, give the date chart in all the three. FIR, closure report, sanction order,
Cognizance charge.
cognizance charge. Picture लिखी दे the Learned Trial Court framed the charge against the petitioner on first case रखे first case रखे वेला 26/8/2016. Since then, the trial of the case is pending. I have perused the proceeding sheet. It indicates that the petitioner is dilly-dallying the trial, largely dilly-dallying the trial, which led to the prolongation. At the same time, the prosecution was also lethargic in prosecuting the case at the pace it is supposed to be. Having said that, the fact that since last 3 decades the case is pending, while exercising the inherent jurisdiction of this court, I am inclined to direct the Learned Trial Court to expedite to dispose of the trial as expeditiously as possible, not later than 3 months hence. 3 months hence. Next paragraph. The petitioner being accused need to extend fullest cooperation. The trial court shall not grant unnecessary adjournment on any pretext, and conclude the trial as directed. The petition is disposed of with this aforementioned directive. All the 3 matters, give the dates. In all the 3 matters, give a slip, dates.
Yes, ma'am. After some time.
Yeah.
Item 4.
All the 3 matters disposed. Yes.
Order be communicated to the.
Obviously, it will be communicated. Yes.
Item 4.
Yes. Next.
Lord, the petitioner challenging the rejection order of 205 application passed by the JMFC Cuttack, and the rejection.
Where is the order? Where is the order?
My lord, under annexure 1 at page
Yes.
11, starting from page 11. And the rejection order is arising out of a, my lord, 138 of NAC matter. my lord, the relevant portion of.
You are the accused, you have,
Yes, my lord. Yes, my lord.
where is the court? Do you have this, what you call, video facility, video conferencing facility?
No, no, my lord.
Where are you staying, by the way? Why can't you
I-
appear?
My lord, the 138 matters,
Hmm.
the Honorable Apex Court decisions is there. The 205 application shall be considered and shall be allowed. And
There
the
is
ground.
nothing of that sort, shall be allowed, there is nothing.
Yes, my lord.
Because they only say that video conferencing you can appear.
No, my lord, 138, in 138 matters, the all the materials is depending upon the documentary evidence. Therefore, in that case, 205 petition may be allowed in favor of the accused person. And the region.
Which judgment says shall be allowed?
My lord, in TG N Kumar versus State of Kerala, my lord, I've cited.
But anyway, if that is so
And my lord, the another thing is,
where is
the
that,
ground of
which
rejection-
paragraph?
But in para 2, at page 2 of that judgment, my lord,
Yes,
in all pending 138 cases.
para 2.
Yes, my lord. Para 2, page 2 of that judgment.
Para 2. Para?
Subpara column Roman I, my lord, in last line, my lord. In next page, my lord.
Yes.
In all pending 138 cases, also applications under section 205 of CRPC shall be allowed, and the accused shall be permitted to appear through their counsel. And the ground of.
These are the suggestions, but what is the ultimate direction? In the light of foregoing, appeal is allowed, it is not returned to the lower court is desired. However, we direct that if the accused person moves in a trial court, an applicant on the board of what is the ultimate direction? The by way of this petition, petitioner is seeking to challenge the order dated 5/5/2022 by passed by JMFC Cuttack in 1 CC number 170 of 2019, whereby his application under section 205 CRPC stands rejected. Full stop. The council is relying upon a judgment of Orissa High Court.
My lord, one is Odisha High Court and another one is Supreme Court, my lord.
Relying upon the judgments of this court in so and the judgment of passed by and judgment of Honorable Supreme Court. So. Okay. And submits that in a case under section 138 in a 138 NI Act, in a complaint case against in a complaint case under section 138 NI Act, the application under section 205 CRPC moved by the accused should have been favorably considered by the trial court. Favorably trial court. Issue notice to the opposite party number, returnable within a week, released on 17th. Take the seat, sir, and come. 18th. Yes, next.
Item 5.
I, my lord, have to take instruction in this case. What happened in the meantime, my lord?
Adjourn. Next.
Item 6.
Lordship, on behalf of my learned senior Mr. Milian Kanungo, I prefer an adjournment.
Adjourn.
Lordship, can you take it up any day in
You are
February?
checking, see, there are people, those who are giving memos every day. If your matter is listed, you don't want to argue, it will come at its own pace. You can't choose the day. Because there are people, those who are trying to get their matter listed. Your matter is somehow listed. You don't want to argue. Let it come. Let it come at its own pace.
Item 7.
Whoever is asking a adjournment, give it in February.
My lord,
Yes.
kindly please with the action.
Adjourn. Very well.
Item 8.
Pass over.
Item 9.
9, you are sir?
Yes. Here, I pray for quashing of the proceeding. Also see that at annexure 1, it starts from page 11. Occurrence of the year 2010, when there was immersion of Lord Ganesh, there was a group class between two groups. As a result of which, apprehending some law and order, at the instance of police, the FIR was lost. But Baleshwar town PS case number 12 of 2020 of 2010 was registered under section 440, 20 BIPC, reading section 33 and 32 of the Police Act and section 25, 27 of the Arms Act. And by the time I was not in the picture. And Lordship, see, police took around 10 years to final charge sheet.
FIR
year 2010.
10 and
Yes.
charge sheet was filed on
2020.
20. Okay.
Yes, Lordship, see the annexure 2, it was filed on 29/2/2020.
Right.
After almost a decade.
Hmm.
And Lordship, see at page 47, the accused column 13.
Agree. 47, huh?
Yes.
Charge sheet, huh? 47.
Yes.
Okay.
Here, charge sheet filed against one Tulu alias Dulu Dolai.
Yeah, you.
Tulu
Yes.
Dhol,
What
yes.
is the allegation against you?
Yes, I'm a member of that unlawful assembly, where a dispute between two members group arisen due to immersion of Lord Ganesh.
Then what is your case?
Hello?
If you are a member of.
charge sheet, page 47, serial number 13,
Huh?
charge sheet is filed against one Tulu alias Dulu Dholo.
Right, right.
I'm not there. Almost I'm residing at Bhubaneswar in the state.
That's the alibi. P of alibi.
Yes,
Will be tested in trial.
yes.
482.
No, I'm not in the picture.
That's right, but it has to be tested in
But I have been
trial.
wrongly charge sheeted. And police yet till
If your
date,
defense is
police is
alibi.
yet to take cognizance nor any effect. But merely I have been charge sheeted, police is bent upon to arrest me.
Arrest you.
I'm
Take
bent upon to arrest me. I am not yet arrested.
Take anticipated bail. Taking the plea of alibi, you will
No.
get it.
According to 2010, almost 13 years have lapsed.
That's right, but
I
that
don't
is the
think
reason
that
you will get it.
in 438
You were not
application-
arrested so far.
No,
10 years they took for investigation. Within these 10 years, they have not arrested you. And you apply 438, immediately you will get in the same day. Why 482? Unnecessary. See, 10 years they took for investigation. They have never arrested you.
no.
They see the allegation, the offenses.
Now on the prayer of the IO, NBW has been issued against me.
Naturally, if you don't take bail, you don't go and appear.
Because
And
by the time
you
occurrence,
have invited that.
I was not in the picture. I was not in the place of occurrence. I was not present. None of the accused persons, they have disclosed my name.
That is a defense.
On what
sir.
basis police came
That
to
is
the
your
conclusion that?
defense. That is, you will be acquitted. That's a different story.
Yeah.
And even what you are trying to say is 482 you have filed to get the bail. That's what you want to say. 482 courts are not the court for granting bail.
You also see the offences at annexed to page 20.
I know, I could see that.
147, 148,
I know, therefore you will
149.
get bail. Why are you so apprehensive? You will immediately the same day you will get bail. Which court will decline bail, you tell me?
No,
In this
because
kind of situation.
matter is the 2010, almost 13 years lapsed.
That is the reason you get bail.
No, whatever question you also be raising, the same court will be raised by the other court where 430
I'll
is
record
listed.
those things so that it will help you in bail and dismiss it. So that you can get bail. Write down.
May I pray for one thing, my lord?
Write down.
Now,
I'll
on the prayer of the IO, NBW is issued, you'll also say that since all the offences are
No,
multipliable.
you have not gone. How can you do that? Write down. The FIR came to be registered on 20th 9
2010.
2010 under various provisions of IPC. against unknown persons,
No, against named persons.
against
29 persons are
against the petitioner and many other accused persons.
No, FIR is not against me.
Huh?
Charge sheet was filed against me.
What
FIR, I'm not named in the FIR.
against many named
Around 29
accused
accused persons, yes.
However, petitioner was not named in the FIR, isn't it? Next, the investigating agency has taken a 10 years
Yes, madam.
to complete the investigation, and eventually on
29 to 2020.
29 to 2010 filed the charge sheet.
No, 2020, my lord. Charge sheet was filed 2020.
29
To 2020.
2020 filed a charge sheet against how many accused?
19 accused persons, madam.
Against
19.
Against 19 accused person, including the petitioner.
Yes.
Including the petitioner under section 147, 148, 149, 440 and 120B IPC. I bail kind video IPC. Read with 32 and 33 of Police Act and 25, 27 of Arms Act. Arms Act. Full stop. Then counsel for the petitioner submits that although within these 10 years, the police have never attempted to contact him, but after filing charge sheet on the statement of the IO, NBW has now been issued. Full stop. Therefore, he has invoked the jurisdiction of this court, seeking quashment of the charge sheet. Full stop. I am afraid the petition afraid the whether the since the charge sheet has already been filed, she has filed.
Therefore, he has never invoked the jurisdiction of the court seeking enforcement of the charge sheet.
And also ask and also asking for no coercive action against him. Full stop. Apparently, the remedy lies elsewhere. Therefore, the petitioner seeks to withdraw this petition so as to avail remedy under law. Remedy under law. Full stop. Remedy under law for his liberty. For his liberty. The petition is dismissed as withdrawn, reserving the liberty as spread. And so you will get the bail. Sessions Court will give the bail.
If process is issued under section 82, 83.
Nothing will happen.
Then 438 application will.
And this court is not inclined to quash the proceeding at this stage. Okay. Item 10. Dispose, huh?
May I please?
Yes.
On the ground of compromise, my lord, this petitioner has filed this application. It's a case under section 440, 447, 341, 294, 506, 436 and 511.
Do not file anything. Anyway, issue notice to the
My lord,
land counsel for the petitioner
That I am
submits that.
appearing for the private opposite party in format.
Where is the joint affidavit?
My lord, I will file, my lord, lordship.
Land counsel, the notice has never been issued.
Yes.
The petitioner has invoked the jurisdiction of this court for quashing of the GR case number so and so, on the ground that they have settled the dispute. He has settled the dispute. How many of you are there?
One.
He has settled the dispute with the opposite party number 2, who is the informant in this case. Mr. So and so enters appearance on advance copy on behalf of the opposite party number 2. Opposite party number. The counsel for the petition, counsel for the parties seek adjournment to file joint affidavit and to make sure that the parties to the proceeding appear before this court on the next date of hearing. List on 16, 17, 18.
Both will appear, my lord.
And with affidavit.
My lord, your lordship may direct to list this matter along with CRLMC number 5180, another, because one petitioner, two cases. So that all the informant will remain present on the same.
Cross cases.
Yes, not cross cases,
Cross cases.
one after
Same-
another.
Of incident,
informant.
two
Same
FIR
No,
as
not,
well.
not same informant. Petitioner is one. Informant is different.
Incident also different.
Yes, incident is also different.
So
Because they are coming from Sambalpur side, my lord, that will.
incident,
law-
incident different. There also he has settled.
Yes,
How many cases you have?
these two, my lord.
What is the offense in that case?
Just like this 506, 447.
You are habitual or what?
No, no, my lord, he is a student, man, good student, but because of his father's.
Learned counsel for the petitioner says that against his client, there is another FIR, registered by
My lord, that
registered by one so and so,
D, this is
registered by one.
D, D Nilakant.
Or D. Nilkar, registered by D. Nilkar. In that matter as well, he has entered into a settlement, out of court settlement. Therefore, he has filed the criminal
CRLMC number 5180 of 23.
5180
80 of 23.
2023. He prays to, he is praying to lease that matter along with the present one on the same day.
25th, your lordship, sir.
25th.
Yes.
25th may not be possible. 25th may not.
Now 19th of
19th. Huh? No, oh, that day will be half day.
Acha. Then 18th, my lord.
18th.
Both the parties will remain present before this court. No? Oh, bless.
Certainly you bring them.
My lord.
Next. 11. Appearance, give the appearance. Yes.
May I please the lords? Here, your lordship,
You click here, na? Yeah, so also appears on advance copy and file the vocal. Yes.
here the petitioner's application before, in this application is a second journey. Before this application, another application was filed for passing of the proceeding because the investigating agency, this is a case of a disproportionate asset. Income, also legal source of income.
What happened to the earlier case?
Earlier case, your lordship, that the record has come. This honorable court disposed of the case on 17th of February 2023 with a direction that in the event the petitioners make an application before the investigating officer, along with by submitting all the documents in support of their stand, their legal source of income, that to be taken into consideration by the investigating officer, and accordingly, investigating officer will have to examine it before submission of final report.
You have given.
Yes.
They have taken to consideration.
No, that is why I have.
Then in the trial you will get the benefit of that.
My lord, here the part.
I am in this 482 stage. I can't keep on calculating how much you have income, how legitimate income, illegitimate income.
My prayer before your lordship not to for the scrutinization all those materials. My submission before lordship, when this honorable court had directed the investigating officer to take into consideration. So the
Where is that order? Where is that order?
Page 48.
48.
Eight.
Yes.
Relevant person. And investigation is still on,
Still on.
my lord.
The order was passed in February 2000.
Maybe still on, then how can you come at premature?
So
My lord,
a case.
here I have, the cognizance has not been challenged, even charge sheet has not been filed. But due to pendants of the
Therefore,
case,
wait,
I am
wait
being
till the
deprived
charge
of
sheet is
my.
filed, wait till,
because of
how
this
much time will you
case.
take to conclude it?
So that instruction I have to take. Into DA case, your lordship knows DA case, it's required time because you have to depend on other limbs of the government. It's a case of
It is a premature.
2021.
Will you withdraw it or do you want an order from me?
My lord, may keep it live or I will.
No, you
find
withdraw
out-
it.
I will
You
find out
withdraw
from
it, it is
authorities.
premature.
Because here.
No authority will help you, I'll tell you. I will not unnecessarily keep pending. There are, see, you are clogging the system. Unnecessary filing at this stage, why have you filed?
No, I have filed because I am suffering on the other side, the service side, I am not.
Maybe
getting
that's
promotion.
what to do.
I am not getting
What
promotion.
to,
I
what
know
is the
that
check
your
period?
lordship-
What is the check period?
Check period, your lordship, affair.
Where is the check period? And what are you working for? Oh, as what?
1985 to 2021. That was the check period.
Yes.
And FIR was registered after search in 2011, 2021. That is 20,
Range officer. You are range officer.
my lord. DFO, Office of the DFO, Deputy Ranger. Deputy Ranger, 1 crore, some odd is the DA.
Raid has taken place.
Raid has taken place and
What
2000.
is recovered?
That the recovery, everything was recovered, and after search, the FIR was registered for disproportionate asset to the tune of rupees 1 crore 23 lakh. So now in DA case, we have to defend other limbs of the government. We have to collect the documents, information from other organizations.
When the FIR was registered?
2021.
अरे कुछ तो ऐसे हो. देखो, the by way of this petition, the petitioner is seeking
Quashing of the FIR and the
quashing
proceeding.
of the FIR
And proceeding.
and further proceeding in vigilance case number so and so. So this is a case registered against the petitioner under section
13 to read with 13(1)(b)
1B
and 12 of the
12 of
PC Amendment Act
PC
2008.
amendment. Okay. PC amendment. And the petitioner making the similar same prayer had earlier approached this court by filing TRLMC 470 of 2023. Full stop. He appears to have contended that he has certain he has many documents on his defense to establish his legitimate income. Now, the coordinated bench of this court, by the order dated 17/2/2023, has been pleased to direct the investigating officer to take into account the representation and documents placed before it while filing the charge sheet.
In accordance with law.
While filing the charge sheet. The relevant is para 6 of the order of the coordinate bench dated 17/2/2023. That is at page 46, para 6. Right. Full stop. The land counsel for the petitioner submits that he has submitted his representation along with the documents before the IO of the case.
Annex 2 is the present.
IO of the case. However, none of the documents are taken into consideration. The land counsel for the opposite party submits that the charge sheet has not yet been filed. Therefore, the apprehension of the petitioner that his representation and the document was not taken into consideration appears to be premature in nature. Therefore, the petition is dismissed, being a premature petition. However, it is left open to the petitioner to legislate all his grievances at the appropriate stage appropriate stage before the trial court. Next.
My lord, one thing, instead of indicating that the trial court, because in the event charge sheet will be filed.
No, you will repeat once again. You, at the charge stage, you can very well argue who stops you. Move an application at 227 if you have all the documents. And the first order, with due respect, the first order, the leniency granted to you should not have been. Can the court direct in what way the investigation will take place? Whether the document to be considered, not to consider? Can the 482 court can say?
No,
Take,
not
it is
document.
prerogative of investigating agency.
No, my
Whether
lord,
they will take into consideration some document or not, that is their prerogative.
not only
Criminal law
document,
re
it is source of
representation
income.
is a foreign to.
That has been.
So
that
what is this?
That was been
You
suggested
give
by the Vigilance
representation,
Department.
you give representation to the police
Yes.
being an accused, and it has to be considered, and a direction to be issued in a 482 court.
No, here,
What is this?
here the situation is not like.
Situation is,
all in regular.
I think you
Yes.
should give me little credit that I understood the matter.
Very,
You
very-
tell me in the criminal jurisprudence,
Right.
can an accused be allowed to give representation and documents
No.
to the investigating agency to be taken into consideration as your defense?
No, not, but in the.
And the
vigilance
leniency
case,
is
it's
given,
something
you
different.
came second time you are appearing.
Vigilance case is something different.
What different? You are accused.
I
Standard of,
would not have approached the again also after getting the order, previous order. Unless I was being affected by my service career.
Obviously, if you have, your conduct is so, see, even if you are acquitted, you have to, you will have to be proceeded in departmental proceeding, because for departmental proceeding, conviction is not required.
No,
Any conduct leading to conviction is enough.
Yes,
Even if you are acquitted, you can be proceeded departmentally.
but departmental proceeding with the present situation, without there being any departmental proceeding, I was not willing to take into consideration.
You
I
should be
said
happy
this
that
case of
department is helping you, not initiating any proceeding. You should be.
Only one thing you will also indicate that I am withdrawing my application at this stage. I am not pressing my application at this stage.
So that you can file one more.
Minor. What more I can say?
I said only premature at this stage.
Only
I say that will not
only-
prejudice you.
I'm not pressing my application at this stage. At this stage, I'm not pressing.
Shall I write after recording this order? Why have you asked me to write so much? Anyway, the counsel for the petitioner seeks to withdraw this petition. Seeks to withdraw this petition, being a premature petition. Dismiss as due.
Item 12. Belgium matter NP to non-actors में NP to issued on 18/12/2023 18/12/2023
18?
12/2023 NP to issue at page 8.
18/12. What happened?
NP was issued due to non-appearance.
NBW.
Yes.
What is the offense?
Offense 302.
302.
34.
Why are you not appearing in the court?
No, they are
After
appearing
getting the-
on next date is of 14/12/2023. The court below on date fixed on 18/12/2020 due to appearance of the present petitioner. But the present petitioner resided at Mumbai Manor. I have ever annexed paragraph 4 of the petition.
How much will you pay? As a cost?
Your Lordship.
We started from first matter.
Your Lordship.
Eh?
Okay.
How much?
Your Lordship.
Huh?
Your Lordship decide.
Why should I decide? You tell me, you have to give it to the bar only.
The 1,000.
1,000, okay.
17 years 10,000
नहीं नहीं 1,000
302
1,000, 2,000.
नहीं 2 जन अछंती 1,000
1,000 each. 1,000 each. The petitioner is facing trial in Kichi Tarna FIR Lugana Kichi Logi file. Offense Kona Kuchi, where from I'll get which is the offense? Petitioner is facing trial in ST case number 120/4 of 2001-2002 under section 302.
201, 30 privates.
302,
201,
201 and
35.
34 IPC. You are the only accused.
Two accused, yes, both.
Huh?
Yes, petitioner. I think.
Two petitioners. Petitioners. There are two accused petitioners. Both of you are granted bail on the same day?
Next day.
Huh? The petitioners are on bail. Petitioners are on bail. However, they defaulted in appearing before the trial court on 18/12/2023. Therefore, the trial court has been pleased to issue NBW against the accused persons for having violated the bail condition. Bail condition. Full stop. Land Council for the petitioner submits that the petitioners are resident of Mumbai. It escaped notice. It escaped their notice to appear in the court on the said date. Having taken into consideration the fact and circumstances of the case, the order dated 18/12/2023 granting issuing NBW against the petitioner is set aside, subject to the petitioner depositing 1,000 each with the High Court Welfare Association, so on, so within a week, the petitioners are directed to surrender before the jurisdictional court and extend cooperation for the purpose of speedy trial without unnecessary seeking adjournment.
High Court Bar Association.
Bar Association. But lucky so that everything should go there. Yes. 13.
Lordship, in this matter, I have challenged Annexure 1, where warrant of arrest has been issued against the petitioner pursuant to order of...
Warrant?
Yes, Lordship. Pursuant to the order of Second Additional Session Judge Bhuvneshwar.
You are on bail?
No, Your Lordship, no, nothing.
Copy may be served, not copy.
Copy already served. It is there.
You are not on bail?
No, Your Lordship, nothing is in custody of the petitioner. He is unaware of any proceeding pursuant to the 135 of Electricity Act, Your Lordship.
Oh.
No such record is...
now you know.
Yes, Lordship.
I'm going to apply for bail.
Your Lordship, I have inquired before the Second Additional Session Judge Bhuvneshwar, but there I found no such record in TR case 157/2017 in the name of petitioner, Your Lordship. This is my...
you got this warrant, huh?
From the police, Your Lordship. Because
but there is no TR case number 157.
Yes, and Second Additional Session Judge Bhuvneshwar, I inquired, but no such case is pending against the petitioner's name, Your Lordship. So my...
why have you not supplied the...
this copy is already supplied. That is why no defect is there. It is supplied.
Copy nahi na mo. Kabe dechun copy. Kali dechun.
No, ta kurburo jodno file is na. On the date of...
Land Council for the petitioner challenging has filed this petition. Listen to the order.
That is why no defect.
Challenging the order dated 8/8/2023 appears to be issued by the
Second Additional Session
Judge Bhuvneshwar in TR case number 157 of 2017. 2017, whereby NBW has been issued against his client, full stop. See, the Learned Counsel for the petitioner submits that he had no clue regarding regarding any case being pending against him, full stop. She has also inquired from the Sessions Court, concerned section court, regarding the TR case number 157 of 2017, and found that there is no such case pending in that court, Therefore, she has filed this petition seeking quashing of the order, which she received from
Police.
from the local police,
Yes.
received from the local police. Issue notice to the opposite parties to ascertain, issue notice to the opposite parties. Meanwhile, the order dated
2023.
appears to have been issued by second additional session judge Bhubaneswar, in TR case number 157 2027 is stayed.
One extra copy.
Yes.
No extra copy.
Yes.
Stayed. Date they go on 16th or 17th.
Okay.
File the process immediately.
Yes, yes.
Maybe a mischief, maybe wrong,
In the course of
maybe
day-
something might have some
In the course of day, I will file.
course of day, huh?
Yes.
17th or 16th, 17th of खत्म करते हैं, ठीक? हाँ.
Extra copy to the.
I'll just come with
May I please, Your Lordship? My lord, in this case, I am questioning regarding a initiation of a proceeding against me under the Money Laundering Act. Now, some amendments are required. I am filing a petition. I have served a copy. So, some prayers have to be made unless I make that maybe.
Okay, then,
So I am filing it in box today. Your Lordship, I call it on next Thursday. Or
on 31st,
31st.
31st.
And some defects they have pointed out. That also I'll try to rectify. Apart from one defect, that is that original copy of the, for which
It's all right, I'll ignore that. Don't worry. Don't worry.
My name, my title wrongly mentioned as Bhuyan. Myself Vivekanand Nayak. My name has been
This,
mentioned.
correct it.
It cannot be corrected that way. Somebody has to identify it.
And you are there to identify being a senior member.
ମୁଁ ତ ଆଉ attest କରିପାରିବିନି ନା କାହାକୁ.
My oral identification will do, don't worry.
My lord,
Yes.
and after the next case,
Yes, 15.
your lordship is calling it on 31st.
31st. That one 31st. Okay.
Your lordship may not say I am seeking trial.
No, I am not saying anything. I'm just simply adjourning. You do whatever you want. No problem.
15, your lordship, it is an old matter. That's why possibly the court has rejected my application under 315 in a check bounce case. After conclusion of the evidence from the side of the complainant and accused statement, one can always file give his evidence under 315. It reads like this: accused persons to be a competent witness. I am an accused. Any person accused of an offence before a criminal court shall be competent witness for the defence and may give evidence on oath and dispose of the charges made against him. Disprove the charges.
You want to examine yourself as a witness,
Myself,
being an accused
being accused.
after 313. It is permissible. What is the problem?
Once his case.
Okay, complete case. Oh, any
What
case.
is any case?
Any case, it is permissible. Accused wants to examine as a defense witness himself. Is a permissible under.
That is permission.
Issue notice to the opposite party number 2. Returnable within 1 week.
Further proceeding in that case. ma'am.
When have we filed this petition?
It's has been filed in May.
China case.
Actually, the case of
Sorry, Tony.
Sorry.
Nice, sir, sorry. ମୁଁ ତ 10 ବର୍ଷ ଯଦି ରଖି ପାରିଲି ଆଉ 6 ବର୍ଷ.
May 2023 you filed. Why this matter was not taken up?
I don't know. Things were such during those periods because selective cases were going to the one bench, not coming, not being listed.
The serial will come. Serial will come.
Or else your lordship may
Most
allow
cases, my lord,
the
that-
him liberty to approach your lordship afresh.
Learned counsel for the petitioner submits that his application, he is an accused in the complaint case.
1 CC 6121 of 2013.
160, the number 1.
Page 7.
Page 7, huh? So under section 138 NI Act. After the accused statement under section 313, he moved an application under 315 CRPC to examine himself as a defense witness, which was turned down inter alia, turned down by the trial court inter alia, stating that the application is not maintainable. Not maintainable. Therefore, he is before this court. Therefore, he is before this court. Issue notice to the opposite party number 2. Opposite party number 2 returnable within 1 week. Full submit. In the meantime, the counsel for the Mr. Sadangi, senior counsel appearing for the petitioner, submits that he would be moving appropriate application for adjournment before the court below, awaiting the order of this court in the present proceeding. He may do so. He may do so. Matter is adjourned to file the process immediately. Then let us on the same 31st now. Both the matters we can hear. Because since you are there, okay, both the matter.
I don't know.
And take immediately process.
Item 16.
Yes,
Item 16 can be taken 1 week after, man.
adjourned.
Oh, pleasure. Item 17.
Oh, my lord, in the present case, the cognizance has been challenged, my lord. Now, my lord, has not faced that matter because all these are the teachers. my lord.
You don't want
During
press?
2010, no, my lord, that cognizance is challenged. But during 2010, my lord, they had a rally, my lord. And in that case, the inspector is the informant in the case. He has lodged the FIR. my lord. And in the meantime, my lord, this honorable court has been pleased that they are on police bail. Till now, they are on bail. Now the process has been issued. The court is insisting for their appearance. They are in
Appear.
different, yes, my lord, I do admit. Now they are in different parts of the state. In the meantime, the rest of the petitioners, there are 45, 46 petitioners were there, accused person. Now, out of them, 27 petitioners have approached this honorable court. And on last 23rd May, my lord, this honorable court has said that first hour, second hour order has been passed. They will surrender before the court because 307 allegation is there.
That is in 482.
482. I am giving
Show me.
that class.
But I am not inclined to.
Only
have this kind of order.
out of the same FIR, same petitioner.
Maybe, but this is not the job of
That has
482.
also been observed is that they are on bail. 41A has been complied.
The 482 petition.
Lordship. In the order sheet also, it is said that 41A is complied. And in the
There are-
cognizance order also, the London Court will have said that they are on police bail. Page 86.
What to do? There is a coordinate bench order.
Subsequent 30, chassis something 307 added, my lord.
Not
That
added,
part-
same. FIR also
Sat, isn't it?
307, no.
307 is.
Hey, this is an order dated.
They were on police
May.
bail, but there's,
That's what, that is why they say Susila Agarwal and give it.
my lord. That's same order. They will
Because I
surrender.
can't deviate, there is an order.
My lord, they will surrender before the.
The petitioner has filed this present petition under under section 482 CRPC, seeking passing of the cognizance order, page 10. Be carefully, right. Page 10, so and so. He submits, the Land Counsel for the petitioner submits that there are as many as how many accused?
Here, my lord, 18. 18.
Total,
Total is 46.
as many as 46
46 as
accused
per the
persons.
charge sheet.
In the 46 accused persons charge sheeted in the present case. Charge sheeted in the present case. Full stop. Out of the 46, about 27 petitioners have earlier approached this court by filing CRLMC number
I'm sorry, my lord, 48.
48.
48. Page 85 it is.
Yes.
Lord.
27 accused persons have approached this court by filing CRLMC 2118 of 2023. The coordinate bench of this court, by order dated 8/5/2023, has been pleased to pass following directions. Copy, Copy those, following directions. Next problem. Land Counsel for the petitioners submits that
So
the
kindly
same.
pause for a moment. The first order is 8/5/23. Then another order I have given, my lord, that has been modified on 1st of August 23, only to the extent of, as because 307 was there, only direction was to dispose of the application. So there was no second our order because the STM cannot give that because 307. That is why it has been modified to the extent.
Following directions. Subsequently, the said order was modified by the coordinate bench on 1/8/2023 as aggravated offense of 307 IPC is added in the charge sheet against these accused persons. The relevant part of the order dated 1/8/2023 is reproduced. Para 2 and EA. Okay? The next, the counsel for the petitioner submits that the similar order may be extended to them as well. Full stop. As well. Full stop. Since the next paragraph, since the petitioners are accused, co-accused in the instant case, they are entitled to the same order. Entitled to the same order. Therefore, while allowing the present petition, the petitioners are directed to appear before the directed to surrender before the court below. Surrender before court below and move bail application If such application is moved, the same shall be dealt with in the similar fashion as has been done in case of the other co-accused person. Thanks.
Great.
Item 18.
Also.
Item 19.
I believe you lost petition of passing of a criminal proceeding in view of the compromise between the party and both of us staying together and living happily as a husband and wife.
Who? Shraddhanjali married to Sushant?
Sushant.
Okay. What is the offense?
498.
Where are they? Where are they? They are not there. That counts for the petitioner.
Not affidavit also filed, my lord.
Filed, but they have to be here. They have to be here. So, okay, anyway, the petitioner has moved. Petitioners have moved this court, seeking quashing up the criminal prosecution initiated against them at the instance of opposite party number 2 on the ground that they have they have settled their dispute. What do you say?
I am for the wife.
Opposite party number 2. You have filed joint affidavit.
My lord.
What do you say? Will you bring them or will I'll quash it?
First for them. Asile better hoga.
Joint affidavit file करो why unnecessary marching them in the court?
Date may be so that it easier, my lord. Other. No, next month. Sometime joint
affidavit is attested. Everything is there. We want to march them to the
Fourth commission.
What do you say? You are doubting your own affidavit?
No, my lord. Little better, my lord, one day.
ठीक है क्या लिखे sir. There is a joint affidavit also filed before this court, reiterating the fact of settlement. The opposite party number 2 has already started staying with the petitioner number 1 in view of the fact that to save the marital life, they want to discontinue this proceeding. So and so appears for opposite party number 2 submits that both the parties will be present in the court on the next date of hearing so as to reaffirm regarding their regarding the factum of settlement, that settlement. Least on when?
Well, next month.
Next Monday,
No, February, 15 February.
15th February. Okay. Letter counsel for petition submits that the court below have court below, na? Court below has now issued NBW kind NBW.
I number 2523.
Where is that? I number 2523. I number 2523. The London trial court has now trial court by order dated 9/4/2015 has issued NBW against his clients, and he seeks stay of the said NBW order. Full stop. Taking into consideration the fact that the parties have settled their dispute and filed joint affidavit. The operation of order dated 9/4/2015 issued by JMFC Pottamundai in GR case number 549 bracket capital 8 oblique 2013 is stayed till the next date.
I also want to take instruction regarding copyright from the IAC. That one. Little better.
Ragada is also appearing for the state, is also directed to confirm the factum of settlement from the
IAC
Pottamundaitan, Police PS Pottamundaitan.
Item 20.
First.
21.
Please, my lord.
Yes.
My lord, here, my lord, the petitioner sought for a direction to quash the proceeding against the present petitioner where the NBW has been issued, my lord, by the London trial court in the special GR case number 7 of 2016. And so far the prosecution allegation is concerned that in the year 2016, my lord, the contraband article of ganja has been recovered from the possession of a vehicle that is Nidheshwar Meher. He was exclusive conscious possession of that vehicle, and so far the present petitioner, he is Jiten Sahu, having no nexus with the alleged offence. Neither he was also read by the party or only that from the mobile of that accused, that Nidheshwar Meher, they came to know this is the mobile number of the present petitioner. For that, he has also made of the as an accused. The matter is 2016, and also the NBW has issued against an innocent, having absolutely no nexus.
You have applied for bail?
My lord, anticipatively rejected.
2016 matter. I am ready to cooperate with the investigation.
That's right, but this is not a court of bail.
Only my prayer.
You have a better remedy in somewhere else. Anticipatory bail rejected, then you go somewhere else.
Only my lord, that is the matter of 2016. Now it is 2024.
Whatever, but you.
Sir, only my lord, my prayer is, I will surrender before the court below. Only protection will be given that.
No. 482s are not meant for that.
Then only.
You satisfy me whether it can be quashed or not. If it
Yes.
That is the case of quashing, I'll quash.
Yes, only my prayer is to quash the proceeding. Suppose I can understand.
Either I should agree or I should not agree on your submission.
Sir.
But where is the question of giving some other relief? Of bail and all.
No. I am
meant for
that is the alternative option I have given.
I think if you would have got the relief in the 438 court, you would not have come here.
My lord, yes.
Yes.
So
That's
only
reality.
Only my lord issue notice to the opposite party. Let them produce the documents. If they found a single material against me, I don't press that matter.
You know
my lord. Sir.
You know the. I'll just write that you want to surrender to the.
No. So only mere surrender means then he will also send remand me to the custody. That is there. Only protection. Because suppose I can understand any a single iota, single material
Charge sheet filed?
No. 2016 matter. And the very person from who the contraband article has been also recovered, he is in custody. That please see the order. Actually there is nothing against me. Not a single.
Where is the charge sheet?
Sir.
Where is the
I have annexed this. Sir, during course of investigation, Sir Rahul examined the complainant and other witness, visited the spot, forwarded the accused to the court, perused this and so. Jana sent the seizure Ganja RFSL Sambalpur for C and.
Where are you reading?
Sir, may I give my.
No, where are you? You might have
That
placed on record.
difficulty is that they might be that page, not page mark. It.
Final form.
Sir.
Okay. I got the final form.
Sir.
Yes. You are named in the final form?
No.
Huh?
No.
In charge sheet you are not named.
No.
Absconder.
Absconder, you must be there. You are Jiten.
That is counted showing.
My name,
Jiten Sahu. You are Jiten Sahu, na?
Sir, Jiten Sahu. My name is
A1.
Yes. Jiten.
A1.
Yes, Jiten Sahu. They have also caught the accused in red-handed when I also transferred.
That part you may
That
be
is there. So what is my role?
absconded.
Absconded means when their envelope has been issued, because basing on that mobile number, they have added me as an accused. Only because of a mobile number. That is the important. So some the bhitar pole. It important. I am to jail of video. Sir, I can understand. So suppose any material is there, I don't have any case. Nothing. The very person who has apprehended at the spot, you are the driver. My law enforcement is show a single document जो तेरे मोन आता allegation होची गोटे देखे दो तो एवं से clearly से the very person was apprehended and he has not disclosed my name, only by from my mobile they got the number, my number, and added me as an accused. Electric current वाले accused कर दो.
Your name is there. Let's see.
My lord, I have got it. At the last page of the charge sheet.
Yes.
Before the last para, in the middle portion I am reading.
29, page 29.
Yes.
Yes.
How his mobile number was found in the vehicle?
No, भूल कौचो.
Yeah, that is there.
Mobile number, mo number thila
The
na.
vehicle and a mobile phone
Let us read it.
found from his possession in presence of the accused,
Yes.
witnesses and the EM at 11:30 PM and obtained their signature as per the law. He served a copy of the seizure list to the acknowledgement under due acknowledgement. He seized the wedding machine of the weighman and made proper jimanama. He also released his brass seal in jima of the weighman with proper jimanama, as the accused was found in excessive conscious possession of the contraband article ganja for transportation and carrying the clandestine business in a prima facie evidence is well made out against him under the 20B 2C of NDPS Act. He explained regarding the ground of his arrest and arrested him on.
That was so far the Meher is concerned. That is only on Meher. He was a. I don't have dispute so far the Meher is concerned. What about myself, Jiten Sahu?
Jiten sir, aso kimti apon pra abscond rasonti.
Abscond rasonti. They caught an accused in the red-handed. When I am transporting that ganja, the vehicle. More road that they can't go. They can't go to Jiten Sahu.
He is not named anywhere.
Sir, no, naming the accused is not a
No, no,
question, my
what
lord.
is his role
Yes.
in the entire case?
Prosecution.
Where is, I'm not
Yes.
able to find anything.
If only they got the mobile number from the accused person, that for that reason they have added me an accused. Nothing.
Two persons were absconded from the vehicle.
Huh?
Two persons absconded from the vehicle. Driver
He
is
is
there.
one of them.
But on being asked, the driver vehicle identified Meher and my lord said,
The identity of the accused,
Jiten.
Jiten Kamis.
Where is that?
Nahi will give.
No, kichi nahi, nothing.
Let us see. ଅଛି ତ ତାର କୋଉଠି FIR ଦେଖନ୍ତୁ page 19.
It starts from sir, submission of a report regarding detection of a contraband ganja.
With due respect to that is, yeah.
With due respect. My lord, after
Without proceeding to this.
23, after 23 line. You also got it?
Yes.
After 23
On
line.
being asked,
Yes.
the driver of the vehicle
Yes.
gave his identity.
Ask,
as
driver is the
Mitesh
accused, sir.
Meher,
Yes.
such and such. He disclosed the identity of one of the absconded person as one Jiten.
Yes.
Nahi.
কিন্তু কোর্ট absconded কেই ହେଲା ନାହିଁ because no one has fled away from the place of occurrence. Only that was that no 2%. That is that.
Why have you absconded then?
No, I have never been absconded. Sir, I have never been absconded.
Are
Then
you
the
that
charge sheet
way?
says you are
Two
absconded.
persons who are absconded from the vehicle.
Driver was the only person. He was also flying the vehicle, and that vehicle also detained, and also from his conscious possession, the contraband article has been seized and he was
Disclose the
arrested.
identity of one absconded person as one Jiten.
Jiten.
Yes.
Aap
He was not absconded from the spot.
Two persons
No.
from the vehicle.
Let the
One
entire,
key.
sir, let
Yes.
the entire record may produce.
Yes, also both.
Sir.
And we found some suspicious contraband like articles and kept in the vehicle. And I gave my identity card. What is the recovery?
Nothing recovered. Recovery is from that his vehicle.
A vehicle
48 kg of
Two
ganja has been
persons
recovered.
there absconded from the vehicle. And driver disclosed the name of the present petitioner.
Driver disclosed the name of the petitioner or from the mobile number you got the
This
my
says that-
number from the accused mobile.
At this stage,
Where is the order of the 438 court? Show me.
Sir?
438 file करते हैं.
Rejection of your anticipated bail.
That is not rightly, it is not with me. I can also collect.
Have you disclosed in the petition that your petition is?
No,
Why have you not given?
because I was not the conducting advocate.
Whatever you are lawyer, this is completely unfair. It is completely unfair. The petitioner has filed the present petition for quashing of the criminal prosecution and and order of cognizance. Order of cognizance.
Issuance of NBW, sir, on 21/6/2016.
Order of cognizance, and you have challenged this order of cognizance.
And the NBW.
And you just see your prayer is very, you have challenged the pass the proceeding and cognizance in connection with so and so. Order cognizance कब है क्या है कुछ भी. When the cognizance was taken. The petitioner has filed the present petition, inter alia seeking the following prayer. Prayer लिखी दो बेटा. Issue notice to the opposite party route, नेकरी ये better interest of justice. Full stop. In the full stop. Then Mr. Ragada, Land Council for the state submits that submits नहीं Land Council for the petitioner submits that now the trial court has issued NBW against the petitioner. White order dated
Dated 21/6/2016.
21/2/2016.
16/16.
And you are coming now.
Sir.
Full sir. He agreed by the said order. Agreed by the said order. Mr. Ragoda, what is the particulars of anticipatory bail do you have?
That is not there, but my instruction that he has filed anticipatory bail.
Before this court?
My lord. But it's not there, my lord. The last date I will produce.
No. I will dispose there. I will not entertain this. What is this? Mr. Ragoda, appearing for the state, submits that.
That part will not recorded, my lord.
Petitioner's prayer for anticipatory bail has already been rejected. Mr.
No, he didn't.
Mr. Panda.
Sir, only may I, sir, request one thing. I have to verify whether anticipatory bail has been filed by the president or not. Because
I am recording the statement only. I will not.
I'll take instruction from that. But
this, because of this only, the very important matters and 482s are pending. These are frivolous petitions. 2016, you have filed nothing. What is the kind of prayer? I don't know. You have not filed any single annexure. And you want urgent hearing of petition at the cost of other people, those who are waiting in the.
No, I have not made.
Right now.
I don't know.
21.
No. Sir. 21.
Sir.
I don't 20 the BLA field file.
Wrongly. No anticipatory bail has been filed by the president.
3159. I don't. I would item.
You can't do it.
20 rachi.
Be sure about what you are saying.
20 the more 20 filed.
After all,
4892.
This is a matter where the FIR was registered way back on FIR.
On sir.
FIR way back on 9/2/2015.
Sir.
And after investigation, charge sheet was filed on 7/6/2016. Inter alia erring. Inter alia erring petitioner as accused number 2. Petitioner as accused number 2. Accused number 2. Full sir. The perusal of the charge sheet indicates that the petitioner have been absconding.
161 ଅଛି abscond ବୋଲି 161 ଅନ୍ୟ ସାକ୍ଷୀ ମାନେ କହିଛନ୍ତି
abscond. There are certain allegations made against the petitioner in the charge sheet, and which are also germinating from the 161 statement of
Sibo Sankar
witnesses. Therefore, this court is not inclined.
Anticipatory bail file is prepared. You'll also mention the number. Anticipatory bail number you'll also mention.
yes. मार्ग दिखला मिल रहा
ABLPL number.
Mr. Ragoda, लिखित ना. Mr. Ragoda submits that rejected.
In ABLPL number.
In ABLPL number
8483/2018.
8483/2018. Full sir.
8483.
Next further. Having taken into consideration the facts and facts of this case, I am of the considered view that this petition is frivolous in nature. Therefore,
other 482 application also disposed of by the Honorable Court.
Is this? BLPL. It is also submitted that earlier the petitioner has also approached this court by filing CRLMC number
3092 of 2016.
2016. Full stop. Perusal. The perusal of the petition indicates that the petitioner has conspicuously concealed all these facts and seeking indulgence of this court. This is very unfortunate on the part of the accused, to approach the court repeatedly without disclosing the particulars of earlier proceedings. नीचे लिखो. Therefore, the petition is dismissed. Petition is dismissed with a direction that he should forthwith surrender before the court below. Forthwith surrender with the court below. Court below. I should have imposed cost, but I am refraining. You filed anticipatory bail, you have not mentioned. You filed earlier 482, you have not mentioned. And see the prayer. The prayer you are asking everything under the sky. The prayer is neither here nor there. If this kind of petitions are filed in High Court level, what will happen?
Now, my prayer is to pass the proceeding because they absolutely.
See your prayer. I have reproduced that prayer. And this is a fit case where at least 50,000 rupees cost should be imposed. I should have imposed the cost on the accused because you are appearing, so therefore you are a senior member of the bar. I shouldn't be harsh on this. But you don't entertain this client of this nature. He might not have told you. He might not have told you. Therefore, I am giving that benefit. And ask him to surrender immediately.
Sir.
23. 20 matrimonial dispute.
Yes.
Husband and wife. And the now
Settled.
has been settled between the parties and maintaining healthy relationship between them. And another 482 application was also filed by the in-laws, other in-laws. That is, in that case, OP number 2 informant has also filed an affidavit that
Same FIR.
Same.
498 and all.
Yes, ma'am.
Show me. Who is appearing for the opposite party number 2? No notice.
That case, today it is fresh. I am.
Give me that.
This affidavit was filed in that.
In that, you have not filed here anything.
No, since it is fresh matter.
Okay. How many accused here in this case?
There are.
This is allowed, huh?
No, this is pending matter. So just filed. It was national to and the proceeding was
Okay,
by
the petitioner has filed the present petition seeking quashing upon FIR number so and so and the second so and so, comma, which is registered at the instance of opposite party number 2. This case is arising out of a matrimonial dispute. Orland Council for the petitioner submits that now the parties have settled the dispute and they started staying together. The other co-accused persons, namely the father, mother,
Yes,
other co-accused persons, namely the other family member arrayed in the said FIR, have also filed another petition being CRLMC number 2747 of 2023 for quashing of the same FIR. In the said proceeding, the informant, that is the opposite party number 2, has already filed a affidavit inter alia stating the fact that she has already settled the dispute with her husband and family members.
they're living peacefully. They also place a child.
In order to save the peaceful matrimonial relationship between the parties, the petitioner seeks a quashing of the FIR. Let this matter be issue notice to the opposite party number 2. Mr. So-and-so accept waives notice in so far in the opposite party number 1. Leaves this matter along with the CRLMC number 2747 of 2023 on let it be on 16th February. 16th February. The parties are directed to file a joint affidavit before this court. They'll appear and appear before this court on the next date of hearing. Both the matter is there any interim relief? Stay of the proceeding, huh?
Right.
Stay of the proceeding
Further proceeding.
in view of the aforementioned facts and circumstances. The IA number 2552 of 2023 is allowed, and the further proceeding in GR case number so and so page so and so is stayed till next date of hearing. Next.
24. Great.
Yes, challenging the order dated 29/6/2022, that's why the learned district under annex of C.
Use the mic, my sir.
My lord.
Yes.
Challenging the order dated 29/6/2022.
What happened in this by this order? 29.
Cognizance was taken against the present petitioner along with
Yes.
two others for the
Yes.
commission of offense under section 166, 171F, 171H, public 34 of the Indian Penal Code. The
Yes.
prosecution story is like this, my lord. On 18/2/2022 at about 4 p.m., the informant Divya Kumar Oram along with others received a reliable information with regard to transportation of huge quantity of amount in a car bearing registration number.
What? Transportation of?
Huge quantity of cash.
Cash, okay, cash, okay. Yes.
In a car bearing registration number OD02BL 6628, which is coming to distribute in between the voter of the GP in obstruct to free and fair election.
Yes.
It is further alleged that at about 4:30 p.m., the informant along with other police personnel proceed to a village and started MV checking in the locality. At about 4:45 p.m., the vehicle was detained, and during the course of search, a sum of rupees 3,33,000 with various denomination of notes found in the gunny bag.
So what is your defense?
My lord,
Your name is there in the FIR.
my lord, your
And
lordship,
charge sheet is filed against you.
charge sheet has
Cognizance is
been
taken.
filed. My lord, your lordship,
What can be done?
It was stated that one Bapi has given the amount to deliver one Ganesh. But in the charge sheet, the Bapi and the said Ganesh was never examined.
You will be executed. Face the trial.
Your lordship may kindly see.
Your name is there in the FIR. Charge sheet is filed.
FIR,
You are finding out some.
my lord, on that day, I was in the election duty in another.
The best case for acquittal. You face the trial. Only one thing could be given is to expedite the trial. That is also not possible in the sense it is the FIR is in 2022.
On the particular day, the petition.
In a 482 proceeding, shall I go into all these things?
Your lordship may expedite the trial. So that
2022 FIR, how can I expedite?
in the meantime, 2 years.
And it appears to be that you must be a political leader or something.
No.
Teacher.
I am a teacher. I am a school teacher. On the particular day.
You are supporting some political leader.
My lord.
No, my lord.
By way of this the petitioner has invoked the jurisdiction of this court under 482 CRPC, seeking quashing of the order dated 29. What is this? 29/6/2022, passed by so and so, or taking cognizance of the offence against the petitioner under section so and so. I have perused the documents placed on record, particularly the FIR and the charge sheet. Perusal of the document indicates that the petitioner is named in the FIR, and after investigation, charge sheet is filed against him. Therefore, the trial court has rightly taken cognizance of the offence against the petitioner. Hence, no interference is called for. called for.
May I
The
say one
right
thing,
to
my lord?
speedy trial, full stop. Right to speedy trial, a fair, free, fair and speedy trial is a constitutional right of every accused. Therefore, apprehension of the petitioner that the trial will unnecessarily prolong is unfounded at this stage. Having said that, it is expected that the trial court will proceed in a manner by which trial court should proceed. Trial court should conduct the trial so as to ensure that the same is concluded as expeditiously as possible.
May I pray
With
one,
this observation, the petition is dismissed. Next.
may I pray one thing, my lord?
Yes,
I will raise all the points of defense.
that is always there.
Coming up charge, that liberty.
Again, you will file a 482. Once that observation will give, then
No,
another.
my lord, I will not.
I will not give you. I will not give you. You have a right to move it. That is inviting another 482. Yes, next. 20?
5.
Okay. 25.
Possible, let's see.
Yes, possible. Next.
27.
Yes.
This is an FIR of the year 2011, my lords.
2011.
My lords. 2011, my lords, March 2011. The facts.
What happened on 13th February 2023? 13th February 2023. This order,
My lords,
File a discharge petition.
you are 227 petition dismissed.
my lords.
Yes, tell me.
My lords, the facts of the case are such that this occurrence happened in a village, my lords.
Hmm.
One person, one of the co-accused in the present case, has stolen a goat, my lords, of a particular lady. After the intervention of the Bhadralok of the village and the village entries,
Stolen what? Gold.
Goat.
Gold ornament.
Cheri, my lords.
Gold.
Cheri,
Gold.
cheri,
Gold.
goat. And after intervention of the village gentries, the goat was returned to that lady, my lords. After that, this particular co-accused, along with the present petitioner, had gone to the house. It is alleged that he had gone to the house of the
That lady.
Wherein he abused her in filthy languages and also said that mo kilomo sangere aschi, which is recorded, my lords. And he will file false cases against you and all of that he said. The present petitioner was only present at the spot, my lords, which is also evident from the statement, my lords. After that, my lords, the petitioner had challenged the cognizance order before this honorable court, which was disposed.
Liberty must be given.
Liberty was given, my
raise
lords.
at the appropriate stage.
After which he filed his discharge application,
And
my lords.
rejected, now you are here.
And now it has been rejected, my lords. My lords, from even accepting the prosecution case as it is, my lords, no case is made out against the present petitioner, my lords. This is what I'm trying to submit, my lords. Even the statements that have been recorded by the police, my lords, none of them even show that the present petitioner had abused. The offences made out against the present petitioner and the co-accused, my lords, are 294, 506 of 34, read with 3 SC Act, because he uttered the name of our caste, which has been done by the other co-accused.
Whatever do you belong to which caste?
I belong to Khandayat caste, my lord.
Khandayat, okay.
And the person.
Then SC/ST is attracted against you.
My lords,
Yes.
provided I have uttered something or I have
That's
made
right. That's
certain
a different,
gesture, my lords.
that's a different test altogether.
My lords.
Yes.
Now, my lords, the present petitioner herein in his discharge application has also stated, I'm submitting, my lords. As per the FIR story, the informant alleged she is a poor SC lady, and the present FIR was filed 9 months after the incident, my lords. That is also there, 6 months of the incident, my lords. One Tapan Khatal had stolen one goat of the informant, for which she had lodged one FIR against him before the Simulia police station. Police had handed over the stolen goat of the informant, recovering it from the other co-accused, my lord. On 29/3/2011 at 6:30 p.m., he scolded her in obscene languages in front of her house. So also scolded her by uttering her caste. And then both went away by motorcycle, my lords. That is the gist of the entire allegations, my lord. The present petitioner before, my lords, is about 60 years old, my lord. He is a practicing advocate in Soro Court, my lord.
Unnecessarily, he's been dragged into this case. This case has
Because
been
you have accompanied the main.
only because he had accompanied Milords. Some incident happens, Milords. Someone always, out of fear or whatever they take, he had a friend who was a lawyer, Milords. He had taken him. That is his max involvement in this Lord Milords. At this point, Milords, 60 years old, he's a practicing lawyer, Milords, in Surakot. And from 2011, he's been dragged on in with this case. All the allegations have been directed towards the other co-accused, Milords, for which the present proceedings against the present petitioner, Milords, I'm praying to be quashed.
You are
Murlidhar Naik, Milords.
then we will have to issue notice to that.
Lady
One thing, my lord. My lord, the case adjourned to 20th-2/2023 for framing was charged, my lord. But the moment, my lord, charge has not been framed, my lord, the case must have been started. Trial must have been started, my lord.
As per my instructions, Milord, it hasn't been framed.
And charge, my lord, the charge, if the moment charge framed, my lord, but this order, my lord, if the quash, my lord,
What is
he has to challenge again.
What is running in my mind is he is a lawyer.
My lord.
He has accompanied him.
My lord,
Accompanied him.
It's not-
Everything is being
Sir,
done by
just-
the co-accused. So the test of Bhajan Lal that the
604.
FIR is taken at its face value, the allegation, whether any case is made out or not. He is only accompanied. He has no overtake is attributed to him.
Milords,
And there is no 120p also.
Milords,
I've seen. If I can understand 120p would have been there.
there was a
Then,
conspiracy.
then I can understand that. So there is, since in the absence of any overtake attributed to him, he being a lawyer and accompanied, to what extent we can.
Only 34 is there.
34 is there.
My lord, charge sheet 34 there.
More than one person, Milords.
34 there.
34 is there.
But that happened, not the, there is nothing in me.
Simply I'll issue notice, let us see.
Milords.
Next date appearing.
Milords,
You
Milords,
seek adjournment.
Stamp reporter, my lord, point out to
Milords,
one.
I've filed an IA for.
Oh,
Milords,
you seek adjournment.
I've made out a case
Issue
before, my
notice.
lords.
The land counsel for the petitioner says, submits that his client is a practicing lawyer. Is a practicing lawyer. He, on the fateful day, he has had accompanied the main accused, against whom the entire allegation has been made by the opposite party, number 2. There is no overtake attributed to the petitioner. He submits that if the allegation in the FIR and the charge sheet is taken at its face value, there is no case made out. So therefore, he is squarely covered by the judgment of the Honorable Supreme Court in Bhajan Lal and so and so. Bhajan Lal so and so. Therefore, he seeks indulgence of this court. Issue notice to the opposite party number 2. Mr. Ragada waives notice for opposite party number 1. Insofar as the interim prayer of the petitioner is concerned, the petitioner submits that he would be requesting the trial court for adjourning the matter, awaiting the outcome of the present petition. Liberty is granted to him to do so.
Milords, if Milords have made out a case, Milords, for issuing notice, Milords. If the proceedings are not
I have
stayed,
issued
Milords,
notice, I have given this
Milords.
intelligence, what do you want?
that may be allowed, Milords, may kindly
No.
hold that adjournment petition may be allowed, Milords. Milords, if the proceedings go on, thereafter notice is issued pending.
Don't try to be very ambitious. You will get an adjournment and I am giving a short date. Short date, let it be a 30th. You sir. 30th of this month.
Tate my lord,
Come,
but
we'll quash it.
if the proceedings in the lower court.
I have
proceed, my
said
lord,
that you move application and.
which may be allowed, my lords, may kindly hold, my lords. That may adjournment.
Then I will ask the trial court to allow. Why can't I allow?
I bow down. I understood, my lords. I understood.
You move the application.
I'll do that, my lords.
You have a good case, we will quash it.
And one
And
thing.
Mr. Ragada will also seek instruction.
It's advocate for that.
He is advocate, let us see.
For that, let us see.
A 60-year.
My lord, one,
But he has to amend the, my lord, the prayer, my lord. The entire proceeding will pass. My lord, the moment charge already been framed, my lord. This order has no.
That technicality will come in your way.
Plus, one more thing my learned senior was pointing out, I think he missed. There's a defect that the novice.
Forget about
My
it.
lords.
Se कौन revision होगा था कौन?
Again,
Court
say
इधर
My lords, sir. I'm grateful. my lords.
That is the reason he is suggesting that amend the prayer. Entire proceeding that is automatically taken care of.
The advocate involved for that.
That is the reason we are trying to,
If my lord
and he is
notice-
also trying to help.
Notice to go to the matter may be compromised.
Maybe.
I'm grateful.
28.
Land Council petition submits that the brief,
Copy not
the
served.
client have taken the brief from him and he is no more prosecuting this case.
For the informant lordship.
So and so appear so and so issue notice to the petitioner. The name of Mr. Akshay Kumar Sahu may be deleted.
Copy may be solved.
Jagar Ketananti ki stuff like that. Date will be March last. Yes.
29.
In this matter, lordships, the petitioner has filed a civil suit. Now, civil suit is admitted, lordship. Therefore.
Civil suits are always admitted.
Admitted. Therefore, petitioner prays for the withdrawal of the petition.
Okay. Land Council, Mr. Naik appearing for the petitioner submits that he has been prosecuting a civil proceeding.
Civil judge, senior division, Bhubaneswar.
Civil proceeding before the court of नहीं जानते ना? नहीं जानते।
Bhubaneswar, CS number 2348 of 2023.
So therefore,
On 13/12/2023, it was admitted. IA also.
Therefore, he doesn't want to proceed with this matter at this stage.
At this stage.
At this stage. Hence,
If
the
occasion
petition is disposed of as premature.
Less.
Premature so that you can, if it is mature, then you can file it.
Less.
It will mature after 2-3 months, you file it.
Less.
Thank you. Thank you.
Bless me.
Item 30.
Yes.
My lord, 1 week time, you kindly allow.
Adjourn.
31.
31 may please, Your Lordship. Your Lordship, Mr. Dash, the conducting counsel is not well. The matter may be taken up any day. Your Lordship.
Speak little louder.
Mr. Dash is not well, Your Lordship. The conducting counsel any day.
Further louder.
Your Lordship, Mrs. Dash is not well. The matter may be adjourned to.
Das.
Yes, the conducting
adjourn.
counsel. Yes, my lord.
While asking adjournment, at least you should be confident. Yes.
32.
32, pass over.
33.
Watching of FIR not done.
30, this is 33.
33.
Sunil Kumar Rautrai.
No, ଆପଣଙ୍କର
Pass over. ଆପଣଙ୍କର କୋଉଟା କୋ ସାଇଡ୍ କୁହନ୍ତୁ କୁହନ୍ତୁ
ଏ ଯୋଉ ପ୍ରସନ୍ନ କୁମାର ମଲ୍ଲିକ।
ହଁ ଆପଣ 32 ଥିଲା
ଓ ସରି 32 ମୁଁ
ପାସ୍ ଓଭର ହେଇଗଲା
କହିଦେବି
ପାସ୍ ଓଭର ଆସନ୍ତୁ ଦିଟା ପରେ କରିବା
ଦିଟା କଣ ସେପଟେ ଗୋଟେ ସିଭିଲ ସୁଟଟେ ଅଛି।
ଆଚ୍ଛା ଆଚ୍ଛା କଣ ଆଡଜର୍ନମେଣ୍ଟ ଚାହୁଛନ୍ତି
ନା ଆଡଜର୍ନମେଣ୍ଟ ମୁଁ ଖାଲି ଜଜ ସିଓଜଙ୍କ ପାଖରେ କହିଦଉଛି ଯେ ଫ୍ୟାକ୍ଟ ଅଫ ଦି କେସ୍ ଇଜ ଲାଇକ ଦିସ୍।
Yes, 32
watching of FIR. FIR lodged on 25/3/2019. The fact of the, for the fact, FIR is lodged on 25/3/2009 is registered for the offense under section 376 2N 341 294 323 417 506 406 109 34 wherein section 6 and 7 of POSPO Act. The fact of the case is like this.
Observation which may help you.
Surrender କରିକି ଆପଣ ସିଏ ଯଦି surrender କରିକି ସେ
That you are next week ରଖିଦିଅନ୍ତୁ ତାକୁ.
ମଙ୍ଗଳବାରକୁ ଆସୁ ମଙ୍ଗଳବାର 15 ତାରିଖ ଛୁଟି
16 ତାରିଖ ଠିକ ଅଛି 16 ତାରିଖ. Yes.
33
Passover, my lord.
Passover. Yes.
34
Yes.
Before the order of cognizance on section 307 is under challenge before your lordship.
Yes.
I don't challenge so far the cognizance order with regard to other allied offences on section 294, 341.
Show me the injury. Show me the injury report.
There is no injury report. I am coming. Exactly, your lordship pointed out the point at which I want to address your lordship.
If you are challenging 307.
307 only on 3 counts. Number 1, there is no injury or injury report. So as to show that the victim sustained some injury. Number 1. Number 2, the allegation, if accepted on its face value without putting it to test up on any way, no offense on section 307 is made out, keeping in view the Bhajanlal case and also other decisions reported by their lordships in apex court.
Right.
Now, number 3, the order of cognizance is by non-application of mind, because even though there is no material, mechanically the trial court, JMFC, he has simply read the charge sheet and quoted those offences. With that, cognizance is taken.
Yes. Let us see injury report.
Again,
you filed any step. What is
I may take your lordship. Running page.
Come to charge sheet now.
That I'm coming, your lordship. Running page 28. Your lordship may kindly have a glance.
All of you, huh? Sumita, Farida, all of you.
Again, all of them are ladies. It arises out of complaint. May I take your lordship's 1 minute? For your lordship's appreciation, may I place it? With your lordship's permission, another 2 minutes. It's a dispute between 2 brothers. The complainant is the sister-in-law, Bhauja, and he accused is the sister-in-law, Nananda, and the other sister-in-law. No.
Some must be from property and all.
All of the quarrel ensued inside the courtyard. Duar bhitere, pacheri padiba pai. E bhai epot nabo, se bhai sepot nabo. Quarrel ensued. Thereafter, the matter was subsided in the village. There was partition between them. But what happens? This complainant came before one of my friends of our fraternity, before this court. A complaint case was filed, which was referred on section 156(3) to treat it as a affair. Thereafter, investigation was taken up. Charge sheet was filed. I need not take your lordship's time, waste your lordship's time. Charge sheet was filed. While charge sheet was filed, the offense of 307 is added and the charge sheet was filed. Cognizance was a mechanical taken. That is under challenge. So for the other allied offences, which is tribal by my states, I don't want to challenge.
Let us see the allegation.
First of all, I may take a lordship to what pointed out that injury report, page 28. 28, running page.
Yes.
Annex of 3 starts from 27.
There is no
28.
injury report found in the record.
Again, there is no injury report found in the record. So in the charge sheet, I have applied for an injury report. There is no injury. So there is no injury report. Then I will.
Come on, charge sheet. Let us see the charge sheet allegation. That's all.
Again, I may take a lordship complaint petition itself, because that is the basis on which your lordship.
Come on,
Complaint,
No,
complaint
no,
with
now,
sir.
now, read the charge sheet.
I'm coming, your lordship. Running page 12. That is complaint with sir. The relevant portion I'm placing. Just 6 lines above from the bottom.
Yes.
So and so, number 1, sat over the complaint, your lordship got it.
Yes, yes, I'm reading.
Sat over the complaint and they tried to press the neck of the complaint with an intention to cause death. So he has not touched the neck. My submission before lordship, he has not touched the neck, he has not pressed the neck, there is no nail mark, nothing of that sort. When he tried the allegation that has been drafted in the complaint petition as well, when he tried to catch hold of the neck, the villagers came and they fled away. Then your lordship, I may take your lordship the charge sheet, as your lordship pointed out.
Yes. There is no strangulation, nothing.
No, there is nothing. Kichi nahi. Charge sheet at the running page 17, your lordship. That is annexure 2.
Yes. What is the relevant part? 26.
Annexure 2.
Come to 26, please.
26, last part.
Yes.
Your lordship.
During the course of investigation, the then court examined complaint and for the examined that the
So and so during course of your lordship. Grievance on section 341, 320, 294, 307, 379, 506 by 34 IBC against the accused so and
Yes.
so.
Yes, Mr.
That's the only thing. Nothing of that.
There is no injury report. There is nothing. Allegations are also.
No, my only prayer before lordship. It's a case of, it's a case of 2013. Well, your lordship may kindly look into the fact. It's a case of 2013. Since 2013, he is going on absconding. Number 1. Number 2, I don't think, my lord, there is any hard and fast law that there must be a injury or there must be anything that it will attract.
There must be allegation. There
Yes,
must be corresponding
exact.
injury also.
No. My lord, supposing, my lord, somebody press the neck, the ingredient itself fulfill.
Where your charge sheet says that?
Charge sheet किसी explanation statement required statement न असले किंती कारण 156(3) रे
There must
investigation
be something.
So they just say जो उड़ा
And
लिखा है जो तो
it
visible
is
होगा.
arising out of 156(3).
Yes, 156(3).
And there is no specific allegation. They are family members. Why 307?
Exactly. 307 must set up must clarify unless until I get the statement of the injured or and another your lordship may kindly see page 30 order dated 25/1/2014. On perusal of the case record I am reading your
And you know what kind of cognizance orders are passed.
Your lordship for a moment. On perusal of the case record, it is found that the victim, namely Usha Parida, of the alleged offences under
Where are you reading?
My lord, I am reading page 30 order dated 25/1/2014.
Yes.
My lord, under section 341, 323, 294, 307, 354, 379, 506, 34 IPC and had sustained injuries and she appears to be in need of interim compensation to be granted under section 357 of CRPC to alleviate her suffering. As such, this case should be recommended that the matter may be taken up by legal.
Sustained injury or injuries.
Yes. So that is why my prayer before lordship, unless until I get the records, I cannot substantiate that whether the complainant has sustained an injury or not,
Yes.
or anything else.
The petitioner has filed this petition under section 482 CRPC, seeking quashing of the cognizance order vis-a-vis the charge, vis-a-vis the offence under section 307. The petitioner, the counsel for the petitioner submits that perusal of the complaint case under section 156 (3) CRPC and the injury report would suggest that indeed there is neither allegation of any assault, nor there is any injury at all on the body of the opposite party number 2. Therefore, barring the cognizance under section 307 IPC, no
307/34 Act.
301 of the 34 IPC, there's the petitioner, the trial court ought not to have taken cognizance. Issue notice to the Mr. Sonso appears for the state and submits that unless the entire record is found, it is difficult for him to make any statement. However, he points out from the impugn order, which indicates that there are injuries sustained by the informant. नहीं कौन थी impugn order कौन नहीं impugn order dated 25/1/2014. It indicates that issue issue notice to the opposite parties. Opposite party written will within 1 week. You have not implemented the informant also.
Opposite party to with your lordship for I am implementing. With your lordship.
Petitioner seek
Complaint. Complaint that
counsel for petitioner makes an oral prayer to implead the informant of the case as the opposite party number 2. Let him do so during the course of the day. Issue notice to the impleaded opposite party number 2, returnable within 1 week hence, on which release the matter on first week.
Stay up in application I filed for a stay of that because that they want to commit the case to the court.
No
of
stay.
session.
If you have a case, I'll quash it. No question of stay. No indirect way of you have been absconding. So that is the reason you file for it.
Try your lordship. I may not insist your lordship, but what your lordship,
no.
I approach
See-
your lordship's
the
conscience that it's a case where a family member will be put to harassment.
See, the case is pending since 2012.
That's true.
And you are not participating.
That
If you would have tried the same thing in the trial court, I think by now you would have been acquitted.
I know your lordship's mind to quash this proceeding, but the fact remains the case is posted to next week. Yes, short adjournment, your lordship may. I will approach the trial court and he'll take care
You
of.
approach it, nobody stops.
No,
No, it is old case, I will not do that.
ନାଇଁ ଆଇଏରେ ଆପଣ ଅର୍ଡରଟା କରିଦେଲେ ମୁଁ ସେଠି ଯାଇ ଆପ୍ରୋଚ୍ କରିବି.
Issue notice on IA number 2590
Oh,
of
black.
2020.
Okay. Or then copy of it.
A copy, you will get it. Same. February, March 20. 20. Yes.
Let's see, here I have prayed for quashing of the proceeding, criminal proceeding, on the ground that the parties, they have settled their dispute outside the court. And I have barred the informant as opposite part number 2.
What is the offense?
Offense is 294.
394.
Sorry, 394. And the allegation is the let's kind of glance to the affair.
Tell me the allegation orally.
Yes, the allegation is like this. They file the petition, the informant and his friend is returning, attending a bhoji the petitioner, the accused person restrained and assaulted and snatched away some amount and mobile phone. This is the only allegation.
Charge sheet filed?
Charge sheet has.
Investigation progress.
It is a matter, FIR is registered on 8/5/2023. Charge sheet must have been filed. I have no instruction at all, but I have arrayed the informant as party. It will be better the informant may be issued notice and
Okay,
after.
issue notice to the opposite party number 2. Mr. Ragada waives notice for opposite party number 1. Return will be within 2 weeks. We'll give it in the 3rd week of February.
Oblige.
Yes.
25.
Item 25 may be taken this week.
Urgent. Next week, we are not sure. Because once it is listed, you have to avail. Otherwise, other people are in the queue. It will go at
33.
You are in 33?
33, my lord. In the meantime, my lord, evidence has been closed. The matter is put up for argument.
The responsible for the petitioner seeks to withdraw the petition. Dismiss it.
35.
Item 35 may pay for 2 weeks supplement.
Copy may be served.
Copy, supply the copy.
My lord, I
Urgent.
serve tomorrow, my lord.
Huh?
If you don't supply next time also, it will be urgent. Better that you supply.
My lord.
36.
36.
Yes.
May I please, Lord?
Yes.
Lord, Annex 3 is the impugned order, my lord. The order taking cognizance dated 21/6/2022, my lord. Passed by the JMFC Raigarh for the offences under section 294, 323, 307, 326, 427, 506 and 34, my lord. Here the case is, my lord, by the Annex 1, the FIR was lodged by one Chandrasekhar Pal, my lord, which has registered against 4 persons, my lord. One Bibhas Bachar, Karthik Bachar, Papu Bachar and Shubham Bachar, my lord. In the FIR, my lord, he is an eyewitness to the occurrence, my lord. He has stated.
You are Tarak Sarkar.
I am Tarak Sarkar. Sir, my lord, the FIR, my lord, he has alleged that your lordship kindly, my lord, I want to draw your lordship's kind attention to page number 15, my lord, the element page of the FIR, my lord.
Yes.
Here, my lord, specific allegation has been leveled against one Bibhas Bachar and Karthik Bachar. Here he has alleged that, my lord, in the midst of the FIR, my lord, he has written Bhuban ଏବଂ କାର୍ତ୍ତିକ ବାଚର ଓ ବିଭାସ ବାଚର ଦୌଡ଼ି ଆସି ନିଚ ଜାତି ଆଜ୍ଞା କହିଲେ ଧାଇ ଆସି ମୋ ଭାଇକୁ ପେଟରେ ଚାକୁ ଛୁରୀ ଭୁଷି ଦେଲେ ସୁନା ଚେନ୍ ଛଡ଼େନି. So far the allegation of 307 is concerned, my lord, it is against Bibhas Bachar and Karthik Bachar. So
34 is there.
34 is there, my lord, I am coming. So, my lord, charge sheet was filed. Charge sheet was filed on the offences, my lord. In the charge sheet, my lord, the investigating officer, my lord, has also specifically stated that, my lord, allegation against the allegation of assault, my lord, against the Bibhas Bachar and Karthik Bachar, my lord.
34 is there. You have to face what is the...
My lord, against Taruk Sarkar, my lord. My lord, although 34 is there, my lord, he is not, my lord, 307 is not attracted. And
Maybe.
other offences are not attracted. Even, my lord, in the, my lord, affair.
That is not, that can't be determined at the cognizance stage. It is somewhere else.
Yes, my lord.
Charge stage. You argue.
So, I may be permitted
The petitioner has assailed the order dated 21/6/2022, whereby the trial court has taken cognizance of the offence under section so and so IPC against him. He contends that as per the FIR and charge sheet, no case under section 307 is made out against him.
These are other offences, my lord, he was not present there, my lord. In the affair also, my lord, he was not present there.
You are questioning 307 or all the entire? Huh?
307 and other offences.
Got those. So he submits that no case is made out against him because he was not present in the spot. Present in the spot. Since the trial court has taken cognizance and the matter is now to be heard by the trial court on the question of framing charges, it is open to the petitioner to raise all these points before the court below. Next, with this observation, the petition is dismissed.
You also can say disposed of, my lord.
Disposed.
Passing of a criminal proceeding due to open both are living due to both are married and living up to my lord. Offense under 363.
Is appearing for opposite party number 2.
Again.
What is the stage of the investigation? 365. What is the allegation?
365.
What is the allegation?
Allegation of the mother of the informed my lord. And Sarajini court and the allegation minor or minor daughter namely Moida. The victim have been to pursue to attend the classes. As usual, see delay in returning home contacted over telephone. He got returned back. Thereafter, he came to.
Have you yourself understood what you said?
Exactly.
What is the allegation? You tell in precisely.
Yes, madam.
What is the allegation against you? Who is the informant? Is
Info is the mother of the victim.
it is Sarojini Panda?
Yes.
Sarojini Panda, opposite party number 2 is the informant.
Corrida. Sarojini Corrida.
Corrida, okay. And against Rajesh Martha, is the accused. Is the accused. What is the allegation made by this opposite party number against you?
My lord, my daughter, my lord, namely Sunolata Corrida. Had been to Oxford College government to attend classes as usual. And when there is delay in return go contractor over phone telephone. Yeah. And that the body is not whatever the present came to know that whatever the present petitioner. Myself.
Played away with the present petitioner.
Yes, madam.
What is the age of this girl?
What
was the age at the time?
Over 18, madam.
19.
Over 19, madam.
19 years.
Like the affidavit and also the mother of the
2005. Date of birth is 8/6/2005. When the offense?
363.
When the offense has taken place? 22. 2005, 22.
After 17 years.
At the time of 17.
17 years.
17.
18 years.
At 17 years, 18 years.
POXO is not involved.
No, POSCO chicken is a fair sini. Can charge it thibo.
Charge it file
2022.
Where is 164 statement?
164 diyo.
At least you should file charge sheet, 164 statement, POXO is there. You want quashing, only file 2 pages FIR and say that quashing.
164 statement not available due to.
Charge sheet is available to you.
That's not so.
Bail paicho 8/1/2024.
In none of the high court in the entire India, this kind of petitions are entertained. Except this court. You want that the entire prosecution, criminal prosecution has to be quashed. No document is filed except the FIR. And you want that FIR should be read and the cognizance order, the charge order, and everything should be quashed. Reading the FIR. Is it possible? 482s are not made for this so casual petitions. You file, amend the petition and tell. You have not said anything. This is wastage of time. Adjourn it for 2 weeks. You do whatever you want to do, 2 weeks. At least file proper petition, proper averments. How will the court know what is happening?
Both are living and married. Both
Both may be living, but she was a minor at the time of offense. whether it is section 12 is invoked or aggravated sexual assault is there or not.
164.
If it is aggravated sexual assault with a minor girl, POCSO is involved, then quashing is not possible. I have to write a judgment.
Yes, sir.
I should know what has exactly happened.
Only offense 363 offense.
A notice has not been issued as yet. We have issued notice, 38, na, item?
Item 37.
37. We have issued notice, no, the
No.
court has not issued.
No,
notice.
this is the first.
And she is appearing on the advance, so that itself creates doubt.
But that too is not sure.
The petitioner has filed this petition seeking quashing of the criminal prosecution initiated against him at the instance of the opposite party number 2, on the ground that they have settled the dispute. From the record it appears that the allegations against the petitioners are regarding the offense under POCSO Act. No document except FIR is filed in this petition. Therefore, the petitioner seeks time to place on record necessary document to substantiate his case. Issue notice to the opposite parties, returnable within 3 weeks. March 1st will be.
One thing, Premala, 160% of the victim.
You file it is your petition.
They have not supplied us due to. I am the.
File charge sheet will do it.
File the charge sheet. 164 statement call for one.
Next, item 38.
38.
May I please, Your Lordship? This is an application under section 482 CRPC, my lord, challenging the order passed by the learned courts below, rejecting my application under section 457 CRPC, my lord. My lord, the learned magistrate has rejected my application under Annexure 3, while in the revision, the learned the additional session judge has rejected my application, my revision application under Annexure 4, my lord. My lord, your lordship may kindly turn to page 10, Annexure 1, page 10, the FIR allegations, my lord.
Yes.
My lord, the petitioner is a, my lord, registered, my lord, general store who has its GST number and SGST number. My lord,
Mr. Mishra, there are some defect in the sense, defect 11 and 18. And when you refer to page 10
yes, ma'am.
And 11, it is just not readable at all. That perhaps the defect. Just nobody can read it.
My lord,
that perhaps the
probably, my lord, the Xerox which has been taken
yes,
out
it's
of
not
this, my
visible.
lord.
And after scanning it is really not visible.
ସେଠି ଯୋଉ ସ୍କାନ କରିଦଉଛନ୍ତି ସେଥିରେ ବୋଧେ ପ୍ରୋବ୍ଲେମ ହେଇଯାଉଛି sir.
That's the problem.
ନହେଲେ
What is this defects, by the way? Ignorable? 10-11.
ସେ 10-11 ଟା ଦେଖେଇଥିବେ ସେଟା ଭଲ ଦେଖା
I'll take it up next week. Your this. That is the basic document. Next week you tell me that is on
Tuesday, your lordship.
Tuesday, 17th.
17.
Mr. Mishra.
And in the meantime, your lordship may also call for the records in, my lord, there is a exactly similar matter, my lord, which has been disposed of 2 cases, my lord. Criminal revision number 163 of 2021.
Criminal revision?
Yes, my lord.
By this court?
By this honorable court.
The same accused or same?
No, petitioner is different, but the point is same. My lord, it is almost a covered matter, my lord.
You get the order there.
order गुड़ाक कोउठी मु पाउनी प्रॉब्लम होची मु जो कॉपीटा रखिची जोटा पाइली एटा भी कॉपीटा ठीक रे देखा जाउनी से पे रेकॉर्डटा आसी गले इट विल बी बेटर एंड यस्टरडे आल्सो अनदर मैटर हैज बीन डिस्पोज्ड ऑफ माय लॉर्ड
by this court,
by this honorable court by honorable justice SK Panigay.
Get that order, we'll see. Otherwise, I'll call for this. No.
That copy I can get
And
it.
by the way, the in any case, notice has to be issued.
Notice to see the state or something.
Okay, nahi.
Nahi, okay. They are to only get the instruction, my lord, with regard to whether within that 90 days, my lord, they have got the permission from the district judge, my lord, the local district judge, to my lord, retain the seized my lord, products. My lord, because
That tobacco you said.
tobacco. Section 13(2) says, my lord, my lord, if the police has seized the tobacco products, and if he does not obtain a permission from the local district judge, my lord,
within 90 days.
yes, my lord, thereafter he cannot retain the products, my lord. With regard to that only, they have to take instruction. Let them take instruction by then, telephonically also they can take instruction.
That section is all absolutely correct, what my learned senior submitted. It will also kindly turn to page 47. Only if the owner is proved, then instruction is necessary to be.
Owner is proved. I have given all the GST.
This is the finding of the in a revision application.
Where is it?
You'll also page 47.
47.
Mind.
Read it.
My lord, I'm reading. In the present case in hand, the article have not been seized from the possession of the present petitioner, but from the Bolero pickup van bearing registered number so and so, which was driven by one Kamadev Naik and its occupant Subham Jodia. Petitioner has neither filed any document of the vehicle showing him as owner of the same, nor has filed any original copy of the invoices of the seized tobacco product with seal and a signature of the distributor from whom he had purchased the same. There is also no materials before this court to ascertain if the provision of section 13 subsection 2 and proviso to section 18 subsection 1 of Court of Act has been complied by the IO of the case. Hence, the authority cited by the London Council for the petition is not applicable. Because you have to prove yourself.
I will just, my lord, reply to that, my lord. My lord, so far as the vehicle is concerned, my lord, I have hired the vehicle, and in the hired vehicle, I was sending the items
You
to
may not be the owner of the vehicle.
I am not the owner of the now the learned court below has said I have not produced the original copies of the documents, my lord. Your lordship knows, my lord, now we are living in a digital, my lord, digital era, my lord.
Yes.
Now, my lord, the GST documents which I have annexed to my documents, my lord, and to 457 application, your lordship will find, my lord. Those are all procured from the, my lord, these are computer
Where have you
generated.
filed? Here have you filed?
Yes, my lord. Page 15 onwards, my lord. These are all computer generated, my lord, documents. So original is not required to be filed.
एक minute. The present petition is filed under Article 482 CRPC against the order dated 3/5/2023 passed by the court of Learned Court of which court is this? Learned Additional Sessions Judge Gunupur, whereby the criminal revision filed by the petitioner is rejected. The petitioner had assailed the order dated 9/11/2022 passed by the trial court, whereby his application under section 13. 457.
Yes.
457 CRPC seeking release of the subject product, subject articles were turned down. The revision court, while turning down the prayer made by the petitioner, has been pleased to record as under 47. 47. The revision court while turning down the prayer of the petitioner in the revision petition, petition has been pleased to record as under petition. The only contention, now needs to be addressed is regarding the ownership of the product claimed by the petitioner, full stop. They appear petitioner. Full stop. Apart from that, the petitioner has also raised the question that under section 13 of COTP Act, 90 days contemplated for taking sanction from the competent authority, which has also not been complied with. Full stop. Issue notice to the respondent. Opposite party, so and so waived notice. The land council for the state land council for the state may seek instruction regarding the aforementioned 2 points raised by land council for the petitioner. Adjourned to these 2 points you just see. He says that these are the
Computer generated
invoices and GST and all. And ask your IO to verify it, genuine or not. Where from you get original? Originals are not given nowadays.
Nowadays, no original is
This document, yes,
print out.
this document has been filed before this honorable court.
He can give.
But
it was filed before the court.
At least what he can do is, he has to give an affidavit under section 65 of IT Act and authenticate this document. On that basis, take indemnity bond and release it.
But court below has observed that no document has been filed.
These documents are
no document. I have read out here before lordship.
Anyway, that is the reason.
It is said, my lord, the original documents are not filed.
Original documents.
Petitioner has neither filed the documents of the vehicle showing him as the
according-
owner, nor has filed any
Vehicle is not
original
question.
copy.
He is not asking release of vehicle. He is asking release of
Yes.
the articles.
I am
Maybe
also-
somebody else may be the owner.
Yes,
How does
yes,
it work?
yes. Only
To
because
verify
of that.
You seek instruction on this.
Yes.
If it required, see, Mr. Mishra, you can also file an affidavit under section 65
Yes,
before
ma'am.
the IO.
Yes.
In the meantime, I will
Yes,
not say all these things.
No, I am fine.
Authenticate it. Authenticate your photocopy.
These are the
photocopy.
computer generated.
At least this is the minimum requirement. You do it, and next time he will say.
That the learned court below could have said, my lord.
Like,
Instead of that, he says, my lord, the original documents are not
Like,
filed, my lord. As
जे
if the
document
learned
purchase
decision
करिबो
is ignorant
ता नाटा
about
रहिबो ना रहिबोनी
present-
इनवॉइसेस रे
कोटा
जे document suppose I have to
Why
purchase
all
from
these
TV.
things happen is perhaps you were not there in trial court.
Yes, that is
No,
why.
That is the reason.
No, no, my
अच्छा
lord.
ना तो नहीं ना इनवॉइसेस
My
रे
lord,
ना
your
कोड
lordship will find annexure 2. I have
ताहार
filed the
invoices आने के
application
रखिबे
which accompanies this.
It is the subjective satisfaction of a court.
Yes.
The trial court was not satisfied. Had
Not
you,
satisfied with regard to the saying that
whatever
the original copies are not
it
filed.
is his
Yes.
discretion to be satisfied or not. Now you satisfy.
Yes, madam.
Here,
I will satisfy here.
what is the extent of the articles? What is
Article
the amount?
suchi that
Quantity, sorry.
page 10 re quantity hochi 50 bags of Bimal pan masala containing 50 numbers of packets, and each packet containing 30 small pouches. V1 brand tobacco 15 bags, each bag containing 4 numbers of kit, each kit containing 2 numbers of small packets, and packets containing 30 pouches. Maruti Khoini 51 bags, each bag containing 50 packets, and each packet containing 24 small pouches. Then 12 cartons of Safal pan masala, each. So these are the.
Okay, given the second week of February.
You lordship may fix up a date.
8th February. 8th February. Yes.
39.
And if your lordship can call for those 2 records also, it will be
No,
complete.
this is enough for me. I don't
Obliged.
like. Yes.
In any lordship, 1 week time will be allowed for removing of defects.
Yes.
40.
2 weeks, we have taken up 2 weeks after. That's last.
Adjourn.
Public.
41.
May I please, my lord? In this application, my lord, on section 482 CRPC, the petitioners both are the husband and wife.
Copy may be served, Lord, 41 item.
41 copy has already been served.
No, no.
Not served. All right. My lord, may I pray one thing? Arising out of a complaint case, cognizance order passed in a complaint case. So may I pray that in the meantime, notice be issued to the complainant, OP number 2?
No, you are challenging what?
I am challenging the order of cognizance.
Why?
My lord,
What
there
is
are
wrong
so-
in it?
My lord?
What is wrong?
My lord, wrong in this sense, my lord. My lord, he has made some allegations which are not absolutely correct. And to the extent that
Correct
my lord,
allegation or not? Try.
my lord, what I am submitting, my lord. Allegation is that the petitioner number 2 had borrowed a cash of rupees 2,60,000 from the OP number 2, the complainant, to purchase a vehicle. And later on, he didn't pay. This is the allegation all about, and it was to alleged that though the transaction was made at Paradip, it is the allegation that the petitioner number 2 asked the complainant, you come to Baleshwar, to my native place where I will make the payment. Though both were working at Paradip. Allegation made that he asked me, you can come to Baripada, to your native, I will pay there. There it is alleged that the accused and some of his associates, they forcibly wanted to obtain signature on some blank stamp papers, abused him, and also he has made allegation assault my caste. This is the allegation all about.
You are SC/ST.
No. The accused, the complainant is an SC/ST.
Naturally.
Yes.
And what are the offenses?
Offenses, my lord, 379, snatching away my gold chain.
Next.
My lord, 406, 420, 506 by 34 IPC, reduced section 3(1) and the arrest of the SC/ST.
No scope of settlement.
No, my lord. All right, let him appear.
Issue notice to opposite party number 2, renewal within 3 weeks. Opposite party number 1 waives so-and-so waives notice to opposite party number 1. You supply the copy.
My lord,
The
by tomorrow.
Petitioner undertakes to supply the copy of the petition to the counsel for the tape. Requisition, file requisition.
May I pray? That may be fixed.
19th February.
My lord.
Yes, next.
42.
I shall remove the defects. Lordship may call it some other day.
Adjourn.
43.
43 mentioned.
Adjournment, my lord.
Huh?
On behalf of Mr. Deo, I seek for adjournment. The counter.
There's the problem. I'm objecting to the adjournment.
That is the reason I told.
The last 3 occasions, Milords will see the order sheet. They have been asking time. They have been getting time. Let me come. Let me just come.
Is there an interim order?
Yes, Milords. And my check bounce case has been stayed. Milords, I'm relying on the court judgment of the Supreme Court.
1 minute, merit, you attack on merit only. Let us see first understand.
There's an interim order. And the interim order he is enjoying. And because of that interim order, my entire proceeding under the check bounce case has been stayed.
On behalf of.
No,
Mr.
but
Deo, I'm
that's
submitting.
right, but you can't take.
I'm submitting. They have filed the counter. I'll file rejoinder.
What rejoinder in criminal matters?
My lord, there is certain requirement, my lord. Certain judgment I'll file. 1 week time I pray for.
Milords, last 3 occasions only judgment, they are filing judgment.
First preemptory order, 1 week time.
I'm
I'm not asking anything more as per the instruction.
Milords, they are just delaying it, Milords. 1 crore 75 lakh they have taken.
1 week time.
They have now enjoying that money.
So and so seeks 500 rupees cost, subject to paying 500.
Not
to be deposited there.
Entire proceeding they have stayed because of this interim order.
I'll give a short.
Much obliged. Milords, next week, any date.
So and so appearing for the petitioner. seeks adjournment in this, adjournment in the matter. Mr. So-and-so, opposite party number 2, sole opposite party, has vehemently opposed the adjournment on the ground that the petitioner have obtained a stay order against him, which is operating against him. This case is arising out of a proceeding initiated by the opposite party under section 138 NI. Taking into consideration the fact that an interim order is operating against the opposite party number 2 since 19/5/2023. Although the matter is adjourned to 30th.
So next week, 16th.
Next week, both of 30th of January. January 2024. But the same is
the cost
subject to the petitioner paying a cost of rupees.
I guess it is 1 crore 75 enjoy করছেন.
What is the check amount?
1 crore 75.
1,000. Subject to paying 1,000, cost of 1,000 to the opposite party number 1, because he is inconvenient, not to the bar. Okay. And this no further adjournment will be granted in this matter.
Yes, no, that may be recorded.
May it please your lordship. Yeah, this is a petition for quashing of the proceeding in city case number 3563/2000.
What is the offense?
My offense is, my lords, 420, 323, 120B.
You are against the cognizance order.
Yes, sir.
You are against the cognizance order.
Against the cognizance and also quashing of the proceeding.
What is wrong in it?
Wrong means the opposite party number 2 in this case, Prabhu Datta, had filed a complaint case in the court of STJM Bhubaneswar. And the learned STJM directed the police station to make an inquiry, investigate the matter. And a city case was instituted. The petitioners in this case, they went on a bail, my lord. Thereafter, the opposite party, Prabhu Datta, his complaint that the opposite party, the petitioner, Lenka, had taken some commodities from his shop and did not pay the same and cheated the amount. Thereafter, they got married, both married. After bail, the petitioner and the petitioner number 1 and the opposite party number 2, Prabhu Datta, they both married. And now they are living peacefully in a one house. They are present here. Last time, the Honorable Court directed, wanted their presence, and also directed the petitioner and the opposite party number 2.
Satpati and Suchita Lenka.
Prabhu Datta having a grocery shop. Suchitra going to the shop and taking grocery items at the instance of other petitioners and did not pay the amount. And there is a love relation between the Prabhu Datta and Suchitra. According they got married. Last occasion, Rasi directed takes the genuineness of the marriage certificate. That is genuine.
Genuine.
And also, my lord, to file an affidavit that in there.
It was listed before this court.
No, my lord. On justice, das. 28/12/2023, my lord.
देखो, petitioners have filed this petition under section.
They are present in the court.
82 CRPC, seeking quashing of the order of cognizance dated 6/4/2021 passed by so and so under section so and so, so and so, so and so. Okay. Next report here, the allegation against the petitioners are that the petitioner number 1
and OP2 got married.
These petitioners were who was getting grocery from whom?
OP2 and petitioner 1 taking grocery from the
petitioner number 1 used to
take grocery.
We used to buy grocery from opposite party number 2 who runs a grocery shop. Who runs a grocery shop. Petitioner number 2 is running a grocery shop, and it is alleged that the petitioner number 1 has been taking grocery from the said shop since the petitioners have failed to pay the due amount to the opposite party number 2, the misunderstanding arose, and an FIR was lost. The FIR is lost. After filing of charge sheet, now the cognizance has been taken by the trial court in the widely impugn order. The counsel for the petitioner submits that now petitioner number 1 has contacted marriage with the petitioner opposite party number 2, and they are leading a happy life. The petitioner has placed on record a marriage certificate dated 6 February 2023. Genuineness of this marriage certificate was verified by the
IIC,
IIC
Infocity PS.
IIC?
Infocity
PS. Mr. Garuda submits that after verification, it was found that indeed the petition number 1 and opposite party number 2 have already married and leading a happy life.
And marriage certificate is genuine.
And the marriage certificate is genuine.
As reported by the district sub-registrar Cuttack.
As reported by the district sub-registrar Cuttack. Parties are present. Petitioner number 1 and opposite party number 2 are present in the court. They are being identified. They filed the Aadhaar card, photocopy of their Aadhaar card. Aadhaar card
Aadhaar card photocopy xerox copy
on record to establish their identity. Identity. Next, having taking into consideration the fact that petitioner number 1 and opposite party number 2 have now married and leading a happy marital life. The happy marital life, the charge sheet, the charge sheet and the charge sheet dated so and so in FIR number so and so, and the consequential proceeding thereof or are set aside, quashed accordingly. The petition ordered accordingly, and the petition is disposed of. Aadhaar card of the record.
Weeks time to file the reply ballot.
Reply?
My lord, I am for the informant.
What
I have
reply in
applied.
the
Yes,
482 petition?
Petitioner shall prayed for was the affair, my lord.
Passing of the FIR.
My lord.
You
I
are
am for the
opposite party
informant.
number?
2,
You want to file reply?
my lord.
I'm applying for the petitioner.
What do you want?
Opposite partner has not filed reply.
You forget about him. What about you? You want adjournment?
Yes, my lord.
Chalo, adjourn. February.
46.
Second week. 46 take no? Yes. Yes.
47.
May I please, your lordship?
Yes.
Initially, on basis of 1cc case, the FIR is being registered. Police investigated the case and then filed closure report in the case due to mistake of fact. Thereafter, on basis of protest petition, cognizance was being taken. So I am challenging the order of cognizance, lordship.
Why? What is wrong in it?
Because
Materials
during
are
the pool,
there on record. Cognizance is taken.
order of 36 to 41.
I have that 36. Page 36 is the order. What is wrong in it?
Wrong in it is that during police investigation, they didn't find anything.
But protest petition is filed, 200 evidences are recorded and now court has
During the,
taken a
when, lordship, when the initial case was filed as per the,
forget about initial case. Closure report is filed.
yes, sir.
156 was filed. FIR was lodged.
Yes,
Closure report filed. Protest petition filed thereafter. And 200 statements were recorded. Material came on record. So therefore cognizance is taken.
No new facts came on record, lordship. The same,
Argue all these points at the appropriate stage.
lordship, can it be taken up after 1 week? Because my learned senior will argue.
Adjourn.
There is.
You don't have a case.
There is the stay of operation of the case.
The stay is there.
But my lord, so submitting my learned friend is wrong in the probability. Their prayer is another. Their prayer is another meaning. So lord, their prayer is to quash another proceeding in which the learned might get directed to the police for registration of the FIR under section 156 of 3 of the Act. That is their prayer. Not that the previous proceeding has to quash what my learned friend submitting that the cognizance taken by the magistrate after the protest petition, that is not their prayer. But my learned friend has not probably gone through the petition there.
Chalo, let it be. Then 29, 30.
There in the last one. Next week.
31st. Next.
47.
Yes.
The matter has been amicably settled between the parties. Joint affidavit has been filed.
Offenses 307.
Offense 307, 386 and 387.
Injury reports from.
Injury reports. Last in Loka Adalat, that case has been listed. In observation, the court has been dealt to.
Where is the injury report? What is the allegation? Offense, weapon of offense?
Case and counter case is there. Both the party filed lodged FIR against each other. The first party 307, 386, 387. The second case registered 506, 294, 324, 320.
In this case, I'm talking about.
That case,
Only the two FIR has been filed. No other document is available.
that case also already been settled. The second FIR is also been settled.
Which FIR, in this case, which FIR you want to cause?
329.
One.
Answer one.
Annexure 1 you want to cause?
Yes.
Yes.
That Annexure 2 yeah, already been compromised.
Request already.
Request.
Where is the order?
So you cannot obtain the informant is also here.
The informant,
No,
where
sir,
is the
sir.
order?
Yes,
placed?
sir. Sorry.
So computer.
That was actually passed in the
Lower court. James, by trial by James.
Compounded,
Compound.
not quas.
Yes, compound.
Because compoundable offense.
Yes, compound.
Yes.
But these are not compoundable offenses. 307, what is the stage of trial? Investigation?
Allegation is that
Investigation. What is the stage of investigation?
charge sheet has not been filed.
Charge sheet must have been filed because it is a case of April, month of April.
April.
3 months ଭିତରେ charge sheet file ହବ.
Injury report ଅଛି record ରେ?
Injury report ଦେଇଛନ୍ତି?
That's the whole difficulty. You want quashing and without filing anything.
In page number 21, the joint affidavit of injury and the informant.
You may be, sir, 307, I need to know what is the injury report, what is the weapon of offense used, whether it is in the vital part of the injury or not. All these things have to be seen, not so casually we can.
Next week I will do the injury. Injury are simple.
ଗୋଟେ ଚାପଟରେ ତାକୁ ଚୋଟ ପକେଇଲା ବେଳେ ସେ ଚୋଟଟା ତା ମୁଣ୍ଡରେ ନ ବାଜି ତା ପିଠିରେ ବାଜିଲା।
କାହିଁରେ?
ଗୋଟେ ଚାପଟରେ
ଚାପଟ?
ହଁ ଗୋଟେ ଚାପଟ ମାନେ ଗୋଟେ ହଣା
chopping.
ସେ ତା ମୁଣ୍ଡକୁ ମାରୁଥିଲା ତା ମୁଣ୍ଡରେ ନ ବାଜି ତା ପିଠିରେ ବାଜିଲା। That is the
FIR. Simple injury.
ସେଇଟା ସେ ଦେବା
Grievous injury, what?
injury report ଦେଲେ otherwise
Very surprising.
ସେ କି ଦବା କଥା ଏଇଟା ଦେଇକିରି ଏଇଟା
Very surprising.
ଏଇ ଧନ୍ଦା କାମ ସରିଗଲା।
Because the petitioner is seeking quashing of FIR. FIR number 191 dated 21/4/2023 NPS Puri, Gop Puri under section so many things 7 pay 7 pay 7 on he seeks quashing of the FIR on the ground that the parties have settled the dispute. There is a cross FIR. There is a cross FIR, which is the FIR cross FIR arising out of the same incident, which is placed on record as Annexure 2. Annexure 2.
Gop PS case number 192.
That is FIR number 1192 dated 22/4/2023.
Yes.
PS Gop Puri.
Yes.
Land Council petitioner states that insofar as the second FIR is concerned, it has already been compounded as the parties have settled the dispute.
Yes.
Therefore, he seeks quashment of the FIR number 191. FIR number 191. If you section 191. PS Go. In this FIR, the allegations are serious, including the allegation under 307 IPC. In the petition, neither the injury report is filed, nor the petitioner is aware of the fact that the charge sheet is filed or not. The petitioner seeks time to place on record the charge sheet and the injury report. Urgent, the matter is urgent to stand over to 13th of February. 13th February.
Entry mode continue. Entry mode
to continue. Yes.
Item 48.
May I please go ahead? Challenging the order dated 6/4/2023 under Annex 3, the petitioner filed this challenge.
48 रे की पार्टी किसी नहीं कॉपी भी हम पाकर नहीं
48 was
I am for the optimal.
138
I am in
and
BC.
नहीं कहीं नहा दे तो रे opposite party
I am in BC. I am for the OP in this case.
And he is appearing.
Yes, I am in BC for the OP.
Yes.
Yes.
Mo koi sir.
Yes.
Petitioner is the complainant and the opposite party is the complainant before the court below, and the present petitioner is the opposite party in a complaint case under section 138 filed by the present opposite party. It is alleged that the present petitioner had taken some hand loan from the opposite party, and in lieu of that he has issued two checks. One is amounting of rupees 20,000, another is 12,000, and another is 1,60,000. Subsequently, the aforesaid checks were reported before the bank, and that was dishonored on the ground that payment stopped by the drawer. Notice was issued, but the petitioner could not reply the notice. After his appearance,
Why could not be?
he could not know the legal procedure. For that reason, he was kept silent. Subsequently, during after his appearance, he had filed a petition to drop the proceeding. As on the prior to issuance of the alleged check, that was missed, and that was already one FIR stationary entry was registered before the police station at just
When the check was issued? Date?
9/8/2000.
Check dated.
Check dated 2/9/21.
2/9/21.
And another is 7/9/21. Another is 7/9/21.
9/21. FIR?
FIR 10/7/21.
Huh?
10/7. Your Lordship, may kindly see running page 26.
Okay, 10/7/21. You have where is that?
Document annexure 2 series, running page 26.
Yes.
Without considering that aspect, the Lord trial court dismissed the
138. NI then.
May I submit?
1 minute.
My,
Yes, tell me what do you want.
what my learned friend relying on the document that goes against him, because the check misplaced on 10/1/2021 as alleged by the counsel of the accused. Cognizance taken on 2/11/2021. There 2 years thereafter, after completion of the pleading, both the witnesses have already been examined. Case is posted for argument. At that stage, they raise the question. Another vital point is the page 26, in which the learned friend relying upon that thereafter he logged the complaint on 9/8/2021. Not that prior to that. At the bottom mirror, page 26.
Check was issued on 2/9/21.
2/9/21.
That is correct. What they stated in the FIR, what is submitted, my lord. He stated in the FIR, the check issued in Jajpur, he resident of Jajpur, he logged the FIR in the Jharkhand after 8 months of the occurrence. My respectful submission, that document is a fraud, fake document. This is also observed by the learned court below.
This is fake. Watch out. This is again.
8 मास ପରେ ଦେଲେ ଝାରଖଣ୍ଡ ଏଫଆଇଆର ଯାଇକି ଆଉ ଓଡିଶାରେ ଦେଲେନି address given the cost title present address permanent address both are at the district of Jajpur, check issued at Jajpur, bank account operated at Jajpur, and after 8 months of the occurrence he made a station diary
I am a
at Jharkhand.
man of a Kalinganagar, at present Kalinganagar, but I am a residing in other place.
Yes.
Your lordship may kindly see the complaint petition. Complainant alleges that he was paid the amount in the month of January 2021. And subsequently, he issued the check and that was deposited on 2/9/21 and another is 7/9/21. Prior to that, I was lodged the report. Your lordship may kindly see.
He's doubting that report itself.
Call for a report, whether the report is genuine.
No, I am not here to
My lord,
contact
your
it.
lordship may kindly see.
You lead the evidence there.
My lord?
You lead the evidence there. And prove this. You prove this complaint, which is at page 26.
My
which you have, this is where, which Thana you have given? Srimati Thana Prabhari Sasaram.
Saram
RIT?
Saram Kela. Why have you gone there?
My lord, for the treatment of my father, I went there, where I lost the check.
You belong to which place?
My lord, I belong to in the state of Odisha. For the treatment of my father, I went there.
So this has to be proved on trial. It can't be taken at the face value. Look, write down. The petitioner is seeking quashing of FIR, quashing of the criminal prosecution arising out of a complaint filed by opposite party under section 138 NI Act. On the basis of the complaint filed by the opposite party ICC case number 206 of 2021 has been registered and petitioner is facing trial therein. The petitioner has now challenged the summoning order passed by JMFC Jajpur Road. When the statutory notice was issued to the petitioner under section 138 NI Act, the petitioner submits that he has not replied to the same. Next paragraph. The only defense of the petitioner is that the check were dishonored as he has asked. Have you placed on record? You have given the letter to the bank for stopping the payment. Have you said that it is the checks were misplaced?
No, my
I was also
Where is that?
That was not with me.
You are saying will not.
The complaint, the report, I was sent to the.
All these things you should have told in the reply. Since you
Madam,
have not replied, then the presumption under 139 operates against you.
Madam,
If it is operates against you, you have to face the trial.
that was not done by the.
And he asked the bank to stop the payment. He is relying upon a handwritten complaint. Where is that? Complaint.
Running page 26.
Complaint made at which police station? This is Jharkhand.
Jharkhand.
Which Saram Kela PS at Jharkhand. The diary entry indicates that he has given complaint regarding the check being misplaced. So, the Land Council for the opposite party contends that this report is fabricated one, fabricated one, and there was no occasion for the petitioner to file the said complaint, file the same complaint on 10/1/2021 in Jharkhand. Although the petitioner is a resident of Jajpur. Jajpur. Next one. All these issues are tribal in nature, and tribal in nature. Full stop. And the proceeding under 482 CRPC is not suffice for the purpose of conducting a mini trial. The defense, all the defense available to the petitioner, all the defense raised by the petitioner in this petition are available to him to prove on record during trial. Therefore, the petition, therefore, interference of this court is not called for, and the present petition is dismissed. Next.
The target can be fixed because trial already concluded. Both the side evidence already closed.
No.
Case is at the argument stage.
I'm not saying anything.
My lord, dispute of.
Next.
May I bring targeted for 2-3 months or my lordship?
Dispose and dismiss.
Dispute of.
As early as
I am
possible.
dismissing it. I am not disposing it.
No, that's
I'm not
correct.
interfering.
Targeted.
Yeah, I don't interfere. How will I dispose it? You have invited this unnecessary. Okay, we'll see. I'll check. Correct it. Yes.
49, your lordship had issued notice on 4/1/24. But the noting says, your lordship will kindly see the cause noting in the cause list that the addressee has left without any intimation. My lord, here the case is a civil suit was filed by the present complainant who filed the 1cc case. Page 30.
That's right, but
My lord, address same is given, whatever given in the claim, whatever given in the FIR, I have given sent a notice. Now she is avoiding notice because now the entire problem has been solved. This suit has been decreed on compromise. She has got everything. Now this Damoclean sword is hanging on my head.
She may not be interested to prosecute you.
Prosecute, but now as the criminal case is pending, my lord, I am in fix. And she is avoiding notice because your lordship will kindly see page 30 for a moment.
Then take Dasti and serve.
Insufficient, my lord. Dasti, how can I serve? My lord, I sent it by speed post. She is avoiding.
Write down. In the last date of hearing, notice was issued to opposite party number 2. Party number 2. Then counsel petitioner submits that the notice, although was issued, was not received by the opposite party number 2, as he left the address. As the electric left the address. The address given by the opposite party in the complaint as well as the allied suit is the same. So therefore, in the right address, the notice was issued. Therefore, the service should be treated as a sufficient service. Sufficient service. Next problem. The petitioner counsel, Mr. Bose submits that there was a suit filed inter se party which has been decreed on
compromise.
Decreed on compromise.
12/11/16.
And the opposite party has got her due to her satisfaction. So therefore, the present FIR needs to be quashed on the strength of those settlement term. Perhaps he further submits that perhaps the opposite party number 2 is already satisfied on her claim. So therefore, she's not bothering herself. She's not bothered regarding the pendency of the present case, taking into consideration the peculiar facts of the present case. The IO of this case is directed to take steps to serve the notice on the opposite party number 2 and report to this court on the next date of hearing. Next date of hearing, let it be on 30th of 30th.
Extra copy may be served. Extra copy.
Serve an extra copy.
And the Mr. Bose undertakes to serve a copy of, for the petition to Mr. Maharaj, who in turn will communicate the same to the IO of the case. Give a copy.
I'll give by tomorrow.
Then next time we'll pass it.
Yes.
Next. And that is on 29th, 30th. Yes.
Item 50.
Wait, please, my lords. Lords, here I have challenged the order of cognizance.
Yeah.
Yes. Please, your lordship. Lords, here I have challenged the cognizance, but my learned friend is praying for a time. It was on 13/10/2023, your lordship.
Next week.
Maybe.
Not next week. When there is an interim order operating, if you want time, let it be. And let come at its own time, whenever it is. Third week.
Third week or then.
Third week.
22nd.
You should have been more diligent and anyway.
Actually, I was not knowing also, I am the petitioner of the opposition.
Petitioner.
No, Mr. Devasis Panda's Vokaratnama is there for petitioner.
Mr. Chand is absent today. His junior is there.
Oh, Mr. Chand is not.
That is why the case is again out.
It's all right, no problem.
There is an interim order.
The interim order is to continue.
Yes.
Again.